Maybe. Please, your lordship, I make the motion for listing a bail application, lordship. Petitioner was arrested on 28 days today, lordship. A small quantity, lordship. So kindly listed on.
Oh, court number 3 is there now. You have to make a mention before court number 3. Looks.
Please, your lordship. In item number 26, affidavit has been filed, your lordship. That may be
26.
your lordship.
So, okay, we're calling it
Lordship.
26, the
Yes,
item
your
number. Okay, we'll call
May I please, your lordship, wait to mention item number 22.
22. Yes.
Lordship, there was an order to file an additional affidavit, which will be filed during court hours. Lordship. Kindly.
Today you are going to file.
Yes, sir.
Okay, if you file, we can call it. You have already filed or not yet filed?
Filed, lordship. Will
You,
file.
you need some time.
Yes, 1 week.
1 week.
Yes.
At the request made by counsel for the petitioner, let the matter be listed 1 week, please, when it can be. 21 and 22. 22 can be. 22 can be. 22 after 1 week. Okay, after 1. Okay.
Please, your lordship. I'd like to mention item number 5, lordship. Sitting is called for on 19, lordship. And
It's not, if let your matter be reached, then let your matter be reached, then we'll call for you.
lordship, I'd like to mention item number 45.
45.
Action for the day. lordship.
City not received.
City not received. Are you on interim there?
No.
You are not on interim? City not received, issue reminder. She's not in interim, she's saying. Not in interim. Yes, Usami, when it can be.
Lordship, on 19,
19, don't make it 19. 19 lots of matters have been already fixed. 19.
first week of June.
No,
or-
he is not in interim, I think.
22,
22, 23 can be. We're fixing it on 22nd.
Lordship.
Release item 1. You are for the respondent, I think.
Lordship.
Petitioner, on the last occasion also, they remain absent in court.
Lordship.
I don't know, there may be any reason. Let be listed after 1 week, then we'll see. None appears on call for the petitioner. Heard Mr. T.
K.
Jain, na? T. A. Jain. K, sorry, K. Jain. And the counsel appearing on behalf of the standing counsel,
DRI.
DRI. Mr. S. Sikai, let the matter be listed after 1 week.
Much of the Lordship.
Item 2.
It is a lordship. My on 14/5 I was arrested in Naka checking. It is alleged that I was driving. I was in a scooty from where my contrabands were recovered, and thereafter my charge sheet was laid in this case. And as my one of the accused person is still absconding, that London trial court has fixed my on this matter on 22/5/25 for his appearance, my lord. So my basic grounds for paying for bail is at page 14.
You got arrested on
14/5, yes, ma'am. 14/5. Page 31, lordship, may kindly peruse for a moment, ma'am. I have also annexed the
Page number?
31, ma'am. Annex 4 is the document based on which I am praying before a lordship for my consideration. And I have also obtained certified copies of these documents, ma'am, which I may be permitted to place before this honorable court, ma'am.
Here one signature of one Hatuni Jamaat is taken up. Why it was taken?
My lord, that instructions I do not have Khatune Jannat.
Because it is seems to be 50, but one witness's signature is there.
Yes, my lord. But that 50, my lord, although my lord do not reflect that grounds which is required by under Article 22 and 50, as Lordship has also decided, my lord, this issue. This is only an intimation. my lord.
Charge sheet filed on when?
Yes, my lord, 8/11/2024. That I have annexed at page 20, my lord.
So one is absconding.
Yes, conduct, my lord.
Yes, Goswami, we are now dealing with this kind of things since, yes, especially the grounds of arrest and all. There was a hearing, in fact, at length with Mr. Kaushik also.
Yes. Also,
But ultimately it was stated that may not be, yes. Here said the issue of court red-handed was discussed in that case. 6 matters were there, and when
Yes.
then we passed the order.
no.
Yes, any other submission?
Regarding that matter, it's in the record matter, and regarding the plea taken by matter, what I submit matter, arrest matter, they are aware of everything matter, because at the time of
That's
arrest matter, they are at the time.
They are
the
aware of,
submission,
they are aware of.
aware. So in my humble submission, my lord, this at this stage, my lord, they cannot take this ground, my lord, because they are already aware they have not taken the ground earlier. Now that stage has gone, my lord, so that is my submission, my lord.
Yes, in that
Yes,
case,
that is, my lord. My lord, this is, my plea is based on Article 22, my lord. And there is no such act or any rule, my lord, which can take away my fundamental right, because, my lord, if there is that, if it is said that I have no right to agitate before this court, my lord, that Article 13 will come, which says any law made inconsistent with the fundamental rights will be void. So, my lord, there is no such law which prohibits, my lord, from raising this issue ground at any stage. And this has been, my lord, decided by your lordship in apex court also, my lord, that
actually what had happened, Mr. Goswami, the question is that this the aware of, obviously he is aware of, in some cases, even after the filing, framing of the charge, they are coming and all. But the question is that in this Bihan Kumar, there is a specific note that even in spite of, even if charge sheet matter,
Yes.
that has to be there. So that is the position now, what to do.
Not,
We are still waiting for any result from this.
yes, that has not come yet.
It has not yet come.
Yeah, my lord.
There may be some. Otherwise, he is involved, I think.
Otherwise, he is involved, my lord. With the commercial quantity.
Mr.
The first color test also is found to be positive.
Involved. Heard Mr. M.A. Chaudhary, the learned counsel for the petition, and also heard Mr. M.P. Goswami, the learned additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted by Mr. Chaudhary that the present accused petitioner got arrested in connection with this case on 14/5/2024. CS has already been filed, but the charge could not be framed till date as one of the accused is still absconding. And hence the completion of trial within a reasonable period cannot be expected at this stage. Next, Mr. Chaudhary further submitted that while issuance of 50 CRPC ground to any river. Same and then Mr. Goswami, Mr. Goswami, the learned additional PP submitted in this regard that that this is a commercial, in case of the commercial quantity, and finding the prima facie case against the present petitioner, the case is already charge sheeted. Further, he submitted that the accused was fully aware about the recovery of contraband and recovery of the contraband full stop. Though it is though he was not intimated in written form in regards to the ground of arrest, but he was verbally informed and he is aware about the ground of arrest. Mr. Goswami accordingly raised objection and submitted that as it is a case of commercial quantity, the rigor of section 37 will follow. Further, he submitted that the accused is a habitual offender and he has the similar kind of offense wherein he was earlier arrested. Baki same thing. This is also case from Sri Bhumi
Yes, ma'am.
to the satisfaction of Sri Bhumi.
Deeply obliged.
Wait, please hold on. Item number 1, external lordship. I could not appear for 5 times lordship.
Oh, see, they have already other side will appear, so it will be listed after 1 week. We are not dismissed it, about to dismiss,
That's
but
kind
on the
of-
last occasion also you will remain absent. So it was supposed to be dismissed today, but we have given 1 week time. After 1 week, it will be listed. Pardon?
Give me submit today, Your
No,
Lordship.
we had already gone. We 1 week time we have given. Yes, number 3.
In this case, my lord, 3 persons were arrested on suspicion, my lord.
Hmm.
2 have been granted bail by your lordship, my lord. This is the order. Only 1 remaining,
Why suspicion? Their recovery was not there.
not recovered, not recovered from us, my lord.
Here your petitioner also got arrested on 12 too.
Or 12, same, on the same length, with 3, on the same footing, my lord, 3 were arrested. 2 have been already granted, and I is remaining, my lord. It was earlier listed wrongly on different codes. So, my lord, little late.
See, here also Goswami, basically he
Same
has
ground.
taken the same ground.
Right.
And apart from that, as per him, the recovery was not from their conscious position and it was on suspicion they got arrested. That is the only submission. And what is this position of the case at present?
Case, my lord, it is in still investigation stage. Charge sheet not filed.
Not yet charged.
Not yet.
Here, my lord,
Yes.
he is the driver, my lord.
Hmm.
He's the
Other were most probably the passenger.
passenger. He is the driver, my lord.
It is all are in suspicion. My lord, it is in the FIR, my lord. Nothing recovered from us. No persons were arrested and caught red-handed. They were subsequently arrested from house. Even without any search warrant, house was searched and we were picked up. It
So
is
they
in the
have
FIR.
submitted Mr. Goswami, he was a driver. But the question is that whether any recovery was from the vehicle he driven or
And the merit, my lord, then they have taken the other ground, my lord. What's going on?
otherwise there are some.
Yes, my lord.
No recovery, it is in the FIR itself, my lord.
Here also we have note down the submission of Mr. Sharma was there on the last, so that they were aware about the grounds, those were here on same, almost same.
Same.
Okay. This is also case from
Mr. Gold.
Sri Bhumi is almost empty, I think.
Nowadays, my lord, the district session judge is also granting bail.
Obvious.
Session judge, additional session judge.
Yes,
So, my
obvious.
lord, rush is down, my lord.
Mhm. Okay, same order, date of arrest is also same, more or less same. Mr. H.R. Chaudhary is appearing here, and otherwise, Mr. M.P. Kusami is appearing here, same address. Okay, Mr. Order is there, you can. Yes, Mr. Biswas. What
My
is
lord,
your
I will
ground?
not make much submission, my lord. Your lordship will see the arrest memo, which is there in page number 28. It is flap mark green.
28,
Green color flap, additional affidavit, green color flap, your lordship. will see.
yes.
My lord will see the reasons for arrest.
Mm.
there is a ground of arrest is given, my lord. Arrest memo. Another scene, column number 10.
Yes.
Now, my lord, will kindly see that Prabir Pukaisto para 37. I have ticked that para 37. What to what, preposition, conjunction, everything says. These are the grounds of arrest. Para 37, which the Honorable Supreme Court have said that it is not a ground of arrest. What to what, I am surprised, my lord, how it can be so similar. What to what?
Yes, yes.
Somebody must have copied from this judgment. Yes, sir. What to what?
What is Tito?
What to what? That's my case, ma'am. That's my case.
Now, this is for your arrest memo, and is there any
Yes,
other?
yes, that is also there, my lord, in my main bail application. There is nothing that is further.
Page 17.
Page 70, there is nothing. Page 17, my lord might see. There is absolutely nothing. The certified copies are with me, my lord. That's it.
For Mr. M. Biswalji, learned counsel for the petition. And also heard Mr. MP Goswami, the learned additional PP, appearing on behalf of state respondent. Yes, Goswami, do you want to submit anything on the reasons of arrest? There is a oblique reasons plus ground of arrest.
Yes.
Is there?
Submission.
Same.
Yes.
M. Biswalji, learned counsel for the petition, so and so. This is an application, the section so and so in connection with so and so. It is submitted by Mr. Biswal that the present, when he got arrested?
My lord, he was, she.
Oh, she.
Yes, she was arrested on
25.
25 to 25.
She was arrested on 25/2/2025, and the case is still under investigation. Charge sheet is not yet filed, no?
No, my lord.
It is still under investigation. Mr.
24,
Guspas further submitted that there is no
24,
grounds of arrest mentioned in the notice issued under section 47 as well as 48 BNSS. However, in the arrest memo, there are some reasons of the grounds of arrest has been communicated to the present petitioner, which are not at all, cannot be considered as a ground of arrest and a ground of arrest, and which is already held by the Honorable Apex Court in case of Pravir Purkasta and in para 37, wherein it has been held as under 37 to deliver. And Baki rest same thing. Para 37. Mr. Goswami submission on the case is still under investigation, and from the forwarding report, it is seen that there are sufficient incriminating materials collected by the IO during the investigation. However, the case is not yet charge sheeted. He further submitted that there may not be any grounds of arrest mentioned in notice under section 47 and 48 BNSS. However, the grounds of arrest has been communicated to the present accused petitioner while issuing the arrest memo. Thus, she is aware about the grounds of arrest under which she got arrested in connection with this case. Perhaps more so, it is a case of commercial quantity, so and so forth. Okay, where is case from?
Judicial trial court, because my lord, why I am saying, because page 15, it is the Honorable Chief Judicial Magistrate Shankar Dev Nagar Court, Hojai. Whereas normally what I understand, my lord, it is session court, because in some NDPS cases, they straight away produce them before the special court. But here I have seen it is produced before the Chief Judicial Magistrate. So, my lord,
No, but it is but subsequent production definitely is before the
then my
special
lord,
judge.
हो जाए-
Because special judge, why it is, I'm saying that it is not a case that it is a committal nature case. It's not
yes,
there,
that is
the
what-
POCSO or NDPS is not
absolutely,
committal nature.
absolutely.
So on the next day of the production, then if it will be
Then,
produced.
my lord, it is
Special judge,
हो जाए Nagaon.
special judge Hojai Naga. Hojai Naga? No, no, Hojai Naga is not there.
My lord, I'll give it to the court master. I'll just.
Sakotem Nagar Hojai is some special judge is not
Yes,
there, I
it
think.
is there.
That's what I'm saying. No,
No.
no, I think it's there.
That's a magistrate court.
You just make it confirmation and then. Special judge is there now?
District judge is- yes, no. Yes,
Oh.
district judge is there, man.
Yes, yes, yes. Oh,
Yeah.
obviously, this is judge is there now. Okay, okay. Yes, yes. I was also in the earlier.
My lord, there-
When
your
it was a
worship,
subdivision, in
that
fact,
now-
that's what.
And the present LR is a district judge on this matter.
Oh, yes.
So it is
Okay, special judge Sakotem Nagar Hojai.
within bracket NDPS.
Within bracket, you put NDPS. Okay.
I'm deeply aware.
এটা 31 to লগাই দিব আর বাকিখিনি সেম থাকিব
Item 5,
yes
Petition also. CD may be called for 19 also.
here okay what nature of case
My lord, 318.
318 okay 3032
3032.
3032 call for the case diary yes when it can be called fixed
Or 20, man.
Maybe
20
20.
20 20
item 6,
My please, your lordship.
yes
Herein, your lordship, the petitioner, they were arrested on 17/4/2025, as on date. On
17/4
17/4/2025.
Huh.
26 days, your lordship, therein. This 13, your lordship.
yes
13 is the FIR, your lordship. Beef was recovered from the possession of the petitioner, your lordship. Only this is the allegation. And here that FIR talks about that they got secret information regarding carrying of transportation of the beef, your lordship. And accordingly, search was conducted and thereafter 200 kg beef was recovered here. And for it, your lordship, they are in custody for 26 days, your lordship.
CDP confirmed. At this stage.
CD
60 days offense, your lordship.
Yeah,
I think-
60 days of it.
I think 26 days, your lordship, I think.
now 200 kg beef
200
is
but
all right but the
not
question is that you
so
should not openly
Investigation-
yes there are some
investigation has to
restrictions
be-
under it now
investigation has to be there, man.
All everything is there, your lordship. Now the case is that further
Okay, we are
custodial
putting
detention is,
we are giving a very short date now.
The- I think, your lordship, the further custodial detention, your lordship, may not be required, your lordship.
It applies from the CD man, whether how he is involved. right?
For everything, your lordship, they have seized, your lordship, nothing is there, your lordship.
Pardon?
Every
Same day, 21st May.
suspected beef has already been seized, your lordship. And 2 persons they were in the vehicle and the petitioner they are, your lordship.
So now they are transporting 200 kgs of beef, in fact, in spite of such the restriction under the law, in fact.
That is why.
Okay, we are
I am
listing a
wondering,
very
your
short
lordship-
date, 19, we are listing it 19 on next Monday. 19, 19/5. Oh. City we call for 19/5.
7,
Yes, sir.
This case, Lordship, the petitioner was arrested on 5/4/2025.
5/4.
Lordship, as on today, 38 days, Lordship. And the FIR registered under section 21B and 29 of NDPS Act, Lordship. FIR will find, Lordship, page 13, Lordship.
Okay, then we'll do one thing. This is a case of NDPS, obviously is an intermediate quantity, I can understand. So 38 days is also almost thing, but otherwise though it is intermediate, there may be parallel and also that has to be seen. And yes, Goswami, when it can be called for.
Lordship, I have annexed the notice under section issued under 47 and 48 also.
Oh, you have annexed. You have
Lordship,
taken that plea also.
Lordship,
Okay, where is the notice?
Page 17, 18.
17, 18.
Forty-seven, page 18, and 48, page 20, Lordship. .29 grams of heroin were recovered. Lordship.
Do you have the certificate copy also with you? So now what to do, Goswami? Even in spite of
Yes,
some
we-
repeated things, they are
Yes,
doing the same
we
thing.
have been repeated times, my lord.
Yes.
We are
Honestly,
instructing,
same.
we are instructing the all, my lord.
Mm.
And also
They're
other cases,
intentional, I think it is.
like 3, 4, 5, all the items, my lord, I've seen, my lord, all the new items.
Yes.
Please take up the notice were issued on 5/4/2025, after Vihan Kumar Lordship.
Hmm?
After Vihan Judgment's Lordship, issued on 5/4/2025.
What 5/4/25?
Issued Lordship.
Ah.
47 notice issued on Lordship, 5/4/2025.
That's what I'm saying, 5/4/25.
After.
Yes,
request for judge-
obviously. And in spite of, from our court, 2, 3 reminders were also been sent to the Secretary, Homes Department, everything, but still they're doing things. So this is, I think, intentional. They are intentional part, I think.
Order, my lord. So that I can take up that matter.
These are the, most probably, these are the intentional thing and that's what is going on. Otherwise, repeated, after, in spite of repeated reminder, if they're doing the same thing, then it's obviously 4, 5 days, 6, 7 days back, I think one similar order was passed by this court. And the copy was also forwarded. Okay, we'll pass the order here. So your petitioner is from?
From Lakhimpur Lordship. Lakhimpur Lordship.
So case is pending before where?
Lordship, the charge sheet not yet filed, Lordship.
Hmm?
And he was produced before the CGM.
Biswanath.
Not Lakhimpur. Not Lakhimpur, Lordship.
Lakhimpur, not Lakhimpur.
Lordship, page 15, Lordship. Forwarding report, Lordship, page 15.
Eta observation লিখিম সেইটো মই আপোনাক পিছত দিম. Just you right now heard Mr. Ayu Chaudhary, the learned counsel for the petitioner, and also heard Mr. M.P. Goswami, the learned additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. Next para, it is submitted by Mr. Chaudhary that the present accused petitioner is innocent and nothing has been recovered from his conscious position. However, he got arrested in connection with this case on 7/5/4/2025 and since 38 days he is in custody. Case is still under investigation and charge sheet is not yet filed against the present petitioner. Next para, Mr. Chaudhary further raised the issue of non-furnishing of grounds of arrest while issuing the notice under section 47 and 48 of BNSS. Same থাকিব. Mr. Goswami submission থাকিব. Mr. Goswami, the learned additional PP submitted in this regard that case is the case is still under stage of investigation and without perusal of the case diary, it is not in a position to say in regards to his involvement in the alleged offense. However, from the forwarding report, it is seen that there are sufficient incrementing materials so far collected by the IO, and the recovery was also from his conscious position. Mr. Goswami accordingly raised objection and submitted that it is not a fit case to grant bail to represent petitioner, only considering the ground of non-furnishing the only considering the ground of non-furnishing the reasons of the grounds of arrest, while issuing notice under section 47 and 48 BNSS. বাকিখিনি মই লিখি কৰি দিছো। Okay, then we'll take up it.
Give your man.
এইটো হেৰি ভিতৰখিনি দি দিম ডিটেকশ্যন তেখেতক দিম।
A copy maybe.
Yes, that's what I'll
No,
keep it.
I'm obliged.
Okay.
Item 8.
My please, Your Lordship. It's matter related to Game and Betting Act, Lordship. The
Achha.
online Game and Betting Act, Lordship. 8% were arrested and they were forwarded to.
How many
the-
persons?
8%, sir, yeah.
Hmm.
Further custodial. Everything has been seized from their position, Lordship. The laptop.
When they got arrested?
34, Lordship. 14 days, Lordship, we consider 3 days.
Game and betting means IPL betting. IPL or what?
No, not specific logic, but in the ground of arrest, it says IPL logic, but says in the FR, no specific against the, it says only online betting.
Laptops, desktop, these are seized.
These things were seized, logic, SIM card, mobile, laptop and desktop logic. Everything has been seized, logic. And the page 30 logic will kindly see the 47, 48 notice logic. There is only one line has been given in the ground of arrest involved in online gambling and betting activities related to IPL. In the notice, it says IPL logic, but in the FR logic, it doesn't mention anything about the IPL.
This page 30 is 48.
Law 48.
48, then 47.
47, 34 logic we can see. Same logic, the only ground of arrest involved in online. I'm not
But,
to that logic, the ground of arrest, I'm not arguing on the basis of a ground of arrest logic. Only thing is that logic, some Game and Betting Act logic, 13 days logic, everything has been seized. Further custodial detention might not be required.
But there's a copy in page number 38. Have you seen notice? Ground of information 48.
Does
Page
it-
ডাঙৰটা
Page
still মৰা
47.
আছে।
I'm not disputing that logic, Jordan, because at the very initial logic, they cannot say in details logic that regarding that online logic you are gambling. That is logic that they
Some
are
grounds
informed.
were given.
Eh?
Some grounds were given,
So
madam.
one grounds are given logic. I am not disputing to that fact
Gambling
logic.
and
My submission is that whether their further custodial detention is required or not. That everything has been seized logic. Investigation will take time logic. They will go through the laptops and it will take time logic. This is an admitted fact. Logic. And they are local person logic. Any point will cooperate with the investigation logic. Of that
They are not local person.
will cooperate logic. Any condition may be imposed upon them. Logic. Any condition.
Copy paste submission details. Kindly see page 18, Lordship. On the
Page 18.
ballot is regarding the involvement. Second paragraph, madam.
Hmm.
Persons who were then brought to Tamulpur based further, one of the apprehended persons, Pawan Kumar, it was found that they were working on behalf of trading company, Krishna Share and Commodity based in Lokha, Bikaner, Rajasthan. The company was verified through SEBI website. It was found that not to be registered. On further inquiry and search of apprehended persons, it was found that they were actually involved in Hawala transaction and opened several WhatsApp groups in order to facilitate and keep record of such transaction. Suspected someone also opened WhatsApp group, namely Assam Parking, two local boys named Alam and Sariful were included in those for illegal transaction having reported in operating online betting sites like Meeting Pro. Several betting sites were there in the.
Hmm.
It's not a, it's an organized crime, my lord.
They are running a farm lawsuit, but I have not
organized
annexed
crime,
anything in the petition lawsuit, as because it is an unregistered one. That is the reason I have not, I could not
They-
annex the document.
And also we'll find all the persons not from Assam, they are not.
No, but the question is that one company is there in their name.
Your
It
lordship,
was unregistered.
Unregistered, that is also unregistered.
But the case is on that unregistered that act, or this is only this regarding the game and betting.
game and betting.
But
So
the-
basically, the other
DNS sections are
sections
also
are
there.
their lordship, but the main.
61 to 316, 318.
But these are also
Yeah.
there.
These are their lordship,
These
but
are there.
basically the main is, 14 and 15 of the Assam game and betting as well.
From the submission of Mr. Munir, most probably the laptop, these have already been arrested.
Lordship.
But from this has to come from where?
Has to come from, the Tamulpur Baksa.
Other section
15,
lordship,
16 can be.
My lord,
15, 16 can it be?
15, 16, no, my lord, next week, my lord, at least.
otherwise regarding
Today's
the
Tuesday,
DNS
right?
lawsuit, that section will come after completion of the investigation lawsuit. The cheating and all, whom they have cheated, where from it came lawsuit. Now, let's say,
But
at this stage,
from the forwarding, it is seen that they are not only involved in this, but they are also.
they are
some of them
not-
are-
it is the final
Has
lawsuit.
to be, some investigation has to be on that regard. At
That
least,
will
my
take time,
lord,
lawsuit.
of that city, on, my lord, 22nd or 23rd. Next week, 1 week, after 1 week.
After 1 week.
Yes, ma'am, because my lord, at least if we bring the CD, my lord, without any investigation, then nothing will happen. Because only, my lord, 10 days in custody, my lord.
So they are also involved in Hawala transaction also.
Yes.
That is the allegation lawsuit, that will take
It's
time.
okay,
lawsuit.
that is
That is
legal
the
allegation.
allegation lawsuit.
That we'll get it, right.
Can it be on 16 lawsuit if possible?
I don't know, Gusami, can it be 16? It will be possible. I don't think so.
16,
19, my lord. the Monday.
16 lawsuit, kind of.
No,
16, it comes only then only.
So,
Otherwise,
let us try lawsuit on 16.
Lord,
Let us try.
city call for
16.
16.
Much obliged, your lord.
Because this, the FSL report, etc., definitely these will take some time. But other part of investigation, what are there? What they have already, we can spare stickers.
That
Okay.
is why, my lord.
Yes.
Much obliged. your lord.
Item 9.
Nothing to Lordship, this allegation is under section 303 and 317(2) and 317(4). And Essential Commodities Act is there and Petroleum Act is also there. Lordship. Actually, the theft that is a petroleum product, crude oil. FIR is at page 12, Lordship.
Hmm.
20 numbers of jerrycan of petroleum product was seized, Lordship, from the custody. And
From custody, custody of
from this
Commercial.
this
From
accused
this
person
petitioner.
is a driver, Lordship, of a tempo vehicle,
tempo.
and the tempo vehicle was hired by someone, and he loaded 20 numbers of jerrycans of petroleum crude oil, Lordship.
The vehicle is not his vehicle. He is the
the
owner of the
driver.
vehicle.
He's the owner and driver of the vehicle. Vehicle was hired by some other person from the tempo stand and was carrying the product.
Hired by whom? Hired by different other person.
So if he doesn't know the name,
No, he is the owner driver of the vehicle.
vehicle, Lordship.
And it was loaded by whom? Other.
By some other person who hired the vehicle from the tempo stand. Lordship, may kindly see paragraph 3, Lordship. On 21/3/25 at about 12 PM, one person took aforesaid vehicle of the petitioner hired from Ananda Bazar, Thamdama tempo vehicle stand and asked him to transport 20 numbers of sealed jerrycans of to Bortola village, Nalbari. According those jerrycans were loaded on the vehicle and the person was coming behind the tempo, beside the tempo. So look, the FIR is there at page 12, Lordship.
Once, my lord, the rejection order will also will find the perusal of the CD is also.
At page?
At page 16, my lord, after perusal of the CD, it was rejected. It could not show anything that it was transported by some other persons, my lord. Nothing has come in the CD.
And now he's
So let
been
it-
up
let it-
since last 53 days. Lord.
Let it come. Short date maybe. The 9th.
Otherwise it is a case of 60 days offense or
60, perhaps 60 days of it.
Yes, but
Seizure.
it's
But,
304, 374 is 90 days, Lord, which is
370.
habitual. But his perjury is not habitual, Lord. He is just the driver of the tempo vehicle. Driver owner, his tempo was hired by someone.
Next week, my lord, people got it.
otherwise 53 days can be
53 days,
considered.
Lord. It's already 52 days.
Because in the rejection order also, is there any, in FIR, is there any, I mean, the contract, the
The-
crude oil or whatever was recovered
The-
definitely
the
from
rejection
petroleum
order is
product
of,
was.
my lord, 1/4. Perhaps because at that time, perhaps the investigation is not, and the license is 1/4, my lord. It now 1 month, after 1.5 months, it can be.
One para is there that I was submitted a bail objection stating that the accused person has information regarding the location of the stored illegal petroleum substance.
Earlier to be recovered, and if the which is earlier to be recovered, that means whether he has some link with some other cases, perhaps, my lord, transporting, visually transporting these products, my lord.
Is there any note in this forwarding also? No.
Yeah, but forwarding for only the date of arrest, my lord. Only now the investigation, lordship, and
Investigation is
After-
completed, Lordship, now 53 days. Lordship.
investigation completes and search it. Lordship may take it up after a week, my lord.
19. Your petitioner is in 53 days. Then? Okay, 19 period. CDB call for 19. Because in forwarding also one notice there, not only in the order of rejection, but in forwarding is also one notice, then he knows the hideout,
Yes,
the areas and all for from the petroleum
Yes, ma'am.
person. 19.5.
Yes, Lordship.
Item 10,
It will also.
Yes.
That is the unregulated reported scheme, that case is my lord. And the petitioner was arrested on 26/3/25. 48 days, my lord. Main allegation is against the, my lord, that his brothers. And he was arrested only because his brother was involved in that case, my lord. Anyway, my lord, in this case, the similar case is, my lord, pending and fixed on 23/5/25. Out of same FIR, my lord.
Out of same FIR.
Same FIR. AB number 1029.
AB
1029.
1029.
25. And that is fixed on 23/5/25. In this case, CD also may be called and that be
Same.
along with that.
it may be along with.
Yes. Heard Mr. H.I. Chaudhary, the learned senior advocate, assisted by Mr. I.U. Chaudhary, the learned counsels for the petitioners, and also heard Mr. S. Locker, the learned additional PP appearing on behalf of state respondent. Let the CDP call for let the CDP call for, and case may be tagged along with the AB number 1029 of 2025, full stop, list on 23/5/2025 for CD. Okay.
item 11,
Today we don't have Arunachal matter, no, no scheme. Today we don't have Arunachal matter. That's what I'm really seeing that is supplementary. I once I actually here was there supplementary list was. So what we'll do, we'll first announce it, then perhaps coming to the items. And then we are list of messages. But is there any prayer that they are going to argue the matter from the principal seat, or is there any? And the house list also shows the name of advocates from Arunachal. Just show me. আমার ইয়ারে কোনো বা আছে? No one is on. Okay, then we kidnap it. Yes, after I jumped it. Yes, sure.
This is also seeking bail on same ground, madam, arrest procedure ground. I was arrested on 27/9/2023. Today is 1 year, 7 months, 16 days.
1 year,
7 months, 16 days.
when we say 2023 date,
Yes, ma'am, 27/9/2023.
and what is the stage of the case?
One partial PW was examined, PW1 was examined partially. The next date of remaining examination date on fixed on 8/5/20. This. My lord, can you see page 32?
Can you fix it on 16/5 or 6?
These are the original certified copies, man. From taking bail, man. Nothing mentioned.
No, here signature, where is the signature? This is not the original, I think.
Is the certified copies.
Huh?
Certified copies. I have annexed it, my lord.
No, here the signature of the accused was also not taken.
Not taken.
Huh?
Not taken. Not taken. I have annexed page 34 and 35.
Here too, they have gone one step ahead. The signature is also not available. Very strange. Place, everything is blank also. Signature is also not there. What to say?
Only iOS signature in.
Lordship. Certificate.
That copies I have. Original.
He
copies.
brought here, the certified copy is with us. Same here, not what to do. Otherwise, definitely it's a commercial quantity, we know.
And it is prior to the Pankaj Bansal case, Lordship. There is also a ground of argument, Lordship, we have. But Lordship, when signature itself is not there, Lordship, what we can say?
Signature, even signatures also not here. Very strange. And in here, while issuing the sections 50, there's no mention about the anything. You can see. Not even the place where the address is also not there. Or again about the ground, so where is the address is also not here. Heard Mr. H.R. Chaudhary, the learned counsel for the petitioner, and also heard Mr. B.S. Kapoor, the learned additional PP appearing on behalf of state respondent. And this is an application under section so and so in connection with so and so. It is submitted by Mr. Chaudhary that the present accused petitioner was arrested in connection with this case on 27/9/2023, and since last 1 year, 7 months, 16 days, he is in custody. The The PW, the prosecution not even completed one PW. Out of how many PWs? Out of 9 PWs cited as the prosecution witnesses. Full stop. Mr.
Out of 7, madam.
Out of 7 witnesses. Next one, Mr. Chaudhary further submitted that there was no grounds of arrest mentioned in the notice issued under section 50 CRPC as well as in the arrest memo. And surprisingly, and not the signature of the accused person is also not even taken while issuing the notice as well as the arrest memo. The বাকিখিনি ground লৈ ল'ব একে same থাকিব. Mr. Locker that the case, this is there was the recovery was from the conscious possession of the accused petitioner, and it is a commercial in nature, wherein the contraband was recovered from the possession of the accused petitioner. Mr. Locker further submitted that the petitioner was well aware about the contraband recovered from his possession, though there is no written communication of the ground of arrest, but the accused petitioner was well aware about the grounds of arrest. বাকিখিনি same থাকে. This is also case from Karimganj, I think. Sribhumi? From Sribhumi. Satisfaction. Is that clear? No other.
Confused that the jail become empty doorstep.
Yes. Only the convicted ones are there, but arrest. This is not the scenario of Assam, in fact, and all over India. Yes, that is the scenario. Yes, 12 is also yours, I think.
Madam. Seeking bail on same ground. Page 29,
12.
30 and 31.
Yes.
It's 29, 30 and 31.
Page 29.
30 and 31. Here, my lord, certified original copy is there.
Original terms. Your petitioner's name is?
Mahudul Hassan, madam.
Mahudul Hassan. He was arrested on
29/11, madam. Yes,
29/11/24.
24.
এটা লিখে যাও, arrested on 29/11/24. Case is charged sheeted, I think. CS submitted. Charge framed or not yet framed? Charge not yet framed. আৰু বাকি no recovery, in লিখিব innocent, no recovery. আৰু পেজত আছে 47. 47 arrest memo and inspection memo. 47 arrest memo, inspection memo. You have not annexed the 48,
And 48 is not given.
whether he submitted the 40, the notice under section 48 is also not even provided to the relatives of the relatives or friends of the present petitioner, intimating the grounds of arrest. Baki same thing. And Mr. Locker submission same thing. That case is already charged sheeted, considering the incriminating materials against the present petitioner, post of cases of commercial quantity, and hence rigor of section 37 will follow. But same time, this is also case from Sribhumi to the specification of the Sribhumi. Even did it.
That is a lot.
Yes.
My lord, this is a regular bail application, my lord. The petitioner was arrested on 7/4/2025 Until today, my lord, 37 days in custody, my lord. The offense is under section 20, subsection B, subsection 2 of B NDPS Act, my lord. That is intermediate quantity. As per the allegation narrated in the FIR, 7 kgs of ganja has been recovered from the present accused petitioner. My lord, my grounds of bail application is, my lord, that non-compliance of section 51 of the NDPS Act. Now, before, my lord, perusal of the FIR is at page number 16. I would like to read the provision of section 50, my lord. My lord, section 50 says, my lord, conditions under which search of persons shall be conducted. So, my lord, when an officer is duly authorized under section 41, 42, and 43 of the NDPS Act, then only he can proceed with the search as provided under section 50 of the NDPS Act. So the officer has to be authorized under section 41 of the NDPS Act. Now, my lord, kindly come to the FIR as page 16, my lord. May I read the contents of the FIR? With due respect, I beg to lodge and written complaint to this effect that a secret information received from the reliable source that one person is carrying 2 numbers of bag which containing suspected ganja, and he is going to travel from Rota Bagan to Dhemaji in train number so and so. Further, he also informed his wedding apparels and also color of bags. Without any delay, I, along with Grinder Borua, so and so, we went to Masbat and pick up the same train from Masbat railway station and ambushed and escorted it. When the train started from Masbat railway station, we checked the coach number so and so as mentioned by the reliable source, and one person along with 2 bags of the train. We, the whole team, had a sharp watch on him. When the train arrived Rangapara North railway station, we apprehended him and inquired about the cannabis. Neither could produce any authority nor given any satisfactory reply, and brought him down from the train at Rangapara. After that, served notice under section 50 of NDPS Act, and I searched the 2 bags and found suspected cannabis. We brought him RPF post Rangapara to interrogate him. During interrogation, he revealed that his name and address so and so, but he cannot say his name and address. He also said that if he delivers the cannabis to the owner at Dhemaji, after that, I immediately informed the matter to the Inspector Dilip Kumar Tiwari of so and so for authority of seize the recovered suspected cannabis, as well as to the OC of Rangapara police station. Now, my lord, here the case is that the informant, first he searched, as per the allegation narrated in the statement in the FIR, then he served the section 50 notice, then he searched, and thereafter he informed to his superior officer to get the authority letter. But section 50 says, my lord, that before a police the search shall be conducted after the authority letter received from his superior officer. Now, my lord, kindly see section 41, clause 2, my lord. The last, my lord, 5 lines, my lord. Section 41, clause 2.
Yes.
Here says, my lord, last 5 lines, my lord, may authorize any officer subordinate to him but superior in rank to a peon, sepoy, or a constable to arrest such person or search a building, conveyance, or place whether by day or by night, or himself arrest such a person or search a building so and so. So here in the statement made in the FIR that he first made the search, and after that he informed his superior officer, that is the Inspector Dilip Kumar Tiwari, to get the authorization letter. So my submission before this honorable court, my lord, from the FIR itself, it shows that there is non-compliance of section 50 of the NDPS Act. Now, my lord, my second ground of my bail application, the persons who at the team of the task force, my lord, along with the informant. Now, my lord, kindly come to the seizure, page 13, my lord.
Yes.
All the signature and seizing witnesses that the member of the task force, my lord, no independent witness were taken at the time of seizing of this contraband, my lord. And number 3, my lord, the ground of my bail application is, my lord, lordship kindly come to page number 22, my lord. This is a medical document of the wife of the petitioner. She is, my lord, under medical supervision and taking the chemotherapy at my lord GMC hospital, my lord. He is suffering from cancer, my lord. And number 4 ground of my bail application is, my lord, that in the forwarding also no criminal antecedent of the present petitioner, and nothing has been involved in any other criminal case has been shown by the investigating officer, my lord.
Yes.
Here in this case, also, lordship may kindly fix it on 19, lordship. In the meantime, we will produce the CD as well as we will also reply to that bunch of cases.
Yes, basically, Mr. Halloway is taking the grounds of the non-compliance of 41, 42, whatever, before the search, making search. But there are, I don't know, there may be, not maybe total compliance may not be there, but there are,
Authorization.
that's what I'm saying, that also the CD has to be there.
That is the list, and the
Because in some cases, there are some cases where the definitely authority has to be there before search. But there are some cases in which most probably the detention or the search may be there, in fact. So no, we'll see all these things. I'm not denying it, but the question is that then we'll fix it on 19th. 19, many matters are there, but okay, then we are fixing on 19th. It has to come from where?
From
Rangapara Teshpur. Okay, 19, you try to produce the 19. Because otherwise your petitioner is in custody since when?
My lord, 7/4/2025, 37 days in custody, my lord.
37 days in custody.
My lord.
Okay, if you call for that one, that you can see the investigation part also, as well as whether any process was there in the collecting the FSL also. So we are fixing it on 19 then.
My lord.
Okay. This
Highly
time 19, CD code, CDP code.
14.
May please your lordship. Here the petitioner was arrested on lordship 8/2/2025. Petitioner was arrested on 8th of February 2025.
Yes.
Lordship may kindly come to page number 58, lordship. I am seeking the bail, lordship, on the same ground. Test memo. Name of the petition is dear lordship, Farooq Ahmed. Page number 59 is the inspection memo. Page number 60 is the notice issued under section 47 of BNSS. Here, lordship, 3 persons were arrested, lordship. The bail order of the co-accused is there at page number 40 and 49 by your lordship. Page number 40. BA number 1141 of 2025. And lordship, thereafter, lordship, page number 49. BA number 1238 of 2025. The certified copies are lordship with me, lordship. So for the recovery part is concerned, lordship, it was recovered from a Bolero vehicle, lordship, of which the petitioner was the driver. And the other 2 persons, lordship, who got already bail, lordship, they were arrested subsequently.
Is not yet charged.
Investigation.
বাকি same থাকিব। খালি আপোনাৰ you is the driver হ'ব ন? Driver of the vehicle arrested on the same date, all the other accused persons,
Yes, Lordship.
same date,
Yes,
8/2/2025.
Yes, Lordship.
Or they will subsequently arrested, the other one?
Subsequently arrested, Lordship, but the forwarding report is same, Lordship. Case number 35, Lordship.
Or for all 8/2/25,
Yes.
8/2/25, huh? Arrested on 8/2/25. He
On
is
the
the,
basis of his statement, the other two persons were arrested.
he was the driver of the vehicle, but he was not aware about the contraband which were recovered from the vehicles and recovered from the vehicle. There was no conscious position of there was no recovery of the contraband from his conscious position. Mr. Loco, the co-accused persons were already granted bail. The mainly the ground of distance. So already the orders are also there in the case. Same order will be there. Your submission, we have already recorded submission on the part of made by the additional PP. Same submission will be recorded here.
Special as Shivu.
Okay.
Hello.
50,
Advocate to same as
I was arrested on 37/2023. Today is 1 year, 9 months, 13 days.
1 year, 9 months.
9 months, 13 days.
You arrested on 20.
37/2023. 30. 37/2023.
Now, what is the progress?
A progress may not even no PW is examined. Charges framed.
Charges frame, no
Charge-
PW.
No PW, charge framed. Charge framed on, my lord, 18/7/2024.
Same ground you have
The
taken
same
here?
ground arrest, page 43, 44, and 45, my lord.
Lordship, here I have my submission is the Lordship here. This is his arrest is Lordship prior to the Pankaj Bansal case, Lordship. So I would like to make my submission, Lordship, on after Lordship can fix it on any other day.
You want to make some submission?
Vihans Kumar is very clear, my lord, regarding these fundamental rights.
Maybe.
Very clear, my lord. Everything is written here. When the
Yes,
Pankaj
As
Bansal
Pankaj
is also-
Bansal judgment order is also there, Lordship, and as per that judgment also it is henceforth, Lordship, it is retrospective. No retrospective is there, prospective, Lordship. And in that case, Lordship, when one standing judgment is also there, and another judgment comes regarding that issue, Lordship, I will make my submission, Lordship. And on 16, Lordship, can fix it, Lordship.
Obviously, you make submission, but we have passed an order in 3-4 cases, I think.
Prior
wherein-
to the Pankaj Bansal. case,
Yes,
Lordship.
prior to that, for those were also prior to Pankaj Bansal, I think.
If there
But
is that,
observation is there that is there any order of prospective or retrospective? That was the issue. Whether there is any retrospective or prospective issues. So unless there are some judgment of Honorable Apex Court that unless it is clarified by the court itself, whether it will be considered as a prospective or
it is
retrospective,
already
these are things that,
clarified.
anyway, we'll fix it on when it can be, yes.
On 16, Lordship.
16 may not be possible. There are some reasons we may not do. Maybe on 2021.
Then Lordship, 21, Lordship.
21. List on 21. By that time, we'll call for the record also.
Lordship.
21, very good. 21/5 and scan copy of the case report along with this case diary be also be called for. Along with the present status report corridor, case diary, present status. Okay, then 21.
16,
May I please?
Please.
Lordship, I am also on the same ground, Lordship. Ground of arrest. Lordship. Page 36, Lordship, 36, 37, and 38, Lordship. The
Yes,
notice issued all three petitions.
Arrest doing actually. Arrest is doing. Arrest doing also.
Arrest 14, 24. The petitioner was arrested on 14/3/24, Lordship.
24.
Yes, Lordship. As on today, Lordship, the petitioner is 425 days behind the bar. Notice controversy.
Charge sheet.
Yes, Lordship. Charge sheet, Lordship. Charge has been framed and 3 PWs are examined, Lordship. The present case is out of Lordship. Guwahati GRPS case number, Lordship, 74 of 24, Lordship.
So you were caught red-handed.
Yes, Lordship, as per allegation, Lordship, from a trade, Lordship. Once it was alleged that from one petitioner, it was found, thereafter, led by her, other 2 petitioners were concerned. In the from the same trade.
So you are the first petitioner.
I'm from all 3 Lordship.
Pardon?
All 3 petitioners, Lordship.
You are appealing for all 3.
All 3. And I have annexed all the relevant documents, Lordship. The arrest memo also I have annexed. There is no single restore of ground documents.
So what are the name of the petitioners? One Goria
Yes, Lordship.
Kumari
Yes.
and
Guria Kumari, Ripu Sudhan Kumar, and Umesh Mahato. Test 36, 37, and 38.
section 50 CRPC. What 47 code 15 is that. Arrest memo দিছে তিনজন 3 petitioners are here. বাকি arrested on 14/3/2000.
It was the date of my forwarding, Lordship, first forwarding.
14/3/2024 na 14/3/2024 charge sheet submitted, charge framed, and 3 PW witnesses are already been examined. গতিকে যেটো incarceration questionটো নাহে
Lordship, otherwise it was earlier it was rejected by this court, Lordship. And thereafter we come with this new ground, Lordship.
rejected for how many or for all?
No, Lordship. For petitioner number 3. Umesh Mahato.
এটা খালি লগাই দিব the petitioner number the earlier bail petition for the petitioner number 3 was rejected by this court. However, the present petition has been filed on the new ground of non-furnishing of the ground of arrest in so and so sense. So law for your submission will be more or less same that it is a case of charge sheet, so they were well aware about the case and the recovery. So this submission will put in the inside. Have you gone through the statement of the statement, not the evidence of the 3 PWs were there?
Lordship.
Is there any incrimination by 3 PWs?
Lordship, as per Lordship, in the cross examination, Lordship, the PW3, Lordship, he admitted that at the time he has not taken the signature of the seizure witness in the seizure list, Lordship. May I read, Lordship, that part?
No, I have already seen.
Otherwise, Lordship,
The prime factor is Lordship, prime point, main point is Lordship, that is the section 47 compliance or not, Lordship. If that is not Lordship, then
everything will go.
everything will go wrong. Even if there is evidence against him or not, everything will go wrong. That is why.
Then, but unfortunate for him, us also. Okay, this is case from where?
What is your base, Lordship?
Guwahati.
What is your base?
Special just.
Special just come.
Okay,
And the item of 15 Lordship, and Lordship has fixed it on 21 Lordship. Item of 15 Lordship.
1-5.
Lordship.
Yes, 21-5.
Can it be a 20 Lordship? Lordship? I have some problem on 2022. 2023 Lordship.
Yes. Okay, 20.
Second. Granted, Lordship.
Different.
70.
May I please, Your Lordship?
Yes, please.
Regular bail application. Lordship, as of today, 717 days behind the bar, Lordship. Lordship, one of the co-accused is already granted bail by coordinate bench. But Lordship, as per notification, it may be taken up as the coordinate bench is not taking criminal matters, Lordship. Lordship, the order is on page 34, Lordship. And I am on the ground of 50, Lordship, 50. It is on page 33, Lordship. Ground of arrest is not furnished, Lordship.
Page 33.
Page 33, Lordship. Lordship, suspected contraband 76.88 kg was recovered, Lordship.
Same.
No, your order of the earlier order where yeah, there was the order, I mean, bail was granted to
Granted.
one of the co-accused.
One of the go.
Here, what was the ground you have taken?
Lordship, the ground of on which ground the co-accused is allowed at Lordship. Lordship, on long incarceration.
Long incarceration.
And only 2 witnesses were examined, Lordship. That is mentioned in the order.
And now you are taking another ground also.
Another ground also. And we will cover, and we are protected by Bihan Kumar, Lordship. There's no Pravir Purkasta and Bihan Kumar, and there's no ground of arrest is mentioned, Lordship.
So you are protected. Where is the notice?
Lordship, 33, Lordship.
Twenty 23 Lordship. Prior to Lordship, that Lordship on same day Lordship and it
27.
3/2022.
So this is prior. Prior.
Lordship.
How? 14 for the order of Pankaj Bansal was 14-3.
It is 17, I probably 17/26.
So you have annexed only the notice.
Yes, Lordship. The arrest memo,
And
I have
other one.
the arrest memo, I have the certified copy.
Now here one more case was there where Mr. Lawful was supposed to submit on not on merit, on some law points regarding the Pankaj Bansal, because arrest was prior to Pankaj Bansal. So that is his submission. So we have already fixed some cases. Here you have taken 2 grounds. One already coordinate bench has already granted bail, considering the long incarceration. That is most probably you are now almost 2 years or more than 2 years.
717 days. Lordship, more than 2 years.
More than 2 years. So that is maybe one of the ground. And apart from that, you have taken these things. But the Mr. Lawford has submitted that he wants to make some submission regarding the Pankaj Bansal, in fact. So we have fixed one matter when it was fixed. Other one is 20. We can fix it on same date on 20.
Lordship, okay.
20 because he is saying that it was prior to Pankaj Bansal, that's all. So let's see his submission and let him submission. In the meantime, we are also calling for the case record. So it will be listed on 20. So certified copies will be with you. You can submit subsequently also with the before this detailed. 22
In
status.
this case, also independent LCR may be called for also if it comes.
Pardon?
In this case, also independent LCR may be called.
Yes,
for
yes, we are calling it.
if
We
it
are calling,
comes.
yes. And here, along with the present status report, we call for. Then the matter will be listed on MR 20.
18.
18 also, Mr. Mehdi is there. Yes.
Here,
Here,
case diary will be required.
yes, there will be required. City before. And yes, when it can be listed, your petitioner is in custody since 23/4.
Lordship.
23/4 in a sense, almost 1 month. Yes, when it
26
can-
also.
20,
6.
26/5.
Can it be a little bit, Lordship, 24 or 23, Lordship?
Will be available, Mr. Law for 23/24,
We can try.
24, 24/5,
Oblige, Lord.
23. She is saying 23 will be best.
Okay.
Oh, 24 is Saturday, 23 we are fixing.
Lordship, oblige, Lordship.
20.
What will be from here? Yes, Mr.
May I please, your Lordship? The regular bail application, my lord. Petitioner was arrested on 24/10/2024.
Direct quotation on the category.
24/10/24.
Page 24.
As on today, my lord, 201 days and round of arrest was not communicated, my lord. Page number 25, 26 and 27. Now the certified copy also, my lord.
The petitioner's name is Alam Hussain.
Aslam.
Huh? Oh,
Aslam.
sorry, Aslam Hussain. Your case is already charged sheeted?
No, my lord.
Not yet?
Not yet, my lord. In 23/4/25, there is an extension order.
Oh, extension order was
Lordship.
there.
The extension order I have an
Or order of extension was passed on when?
23/4/25. On 181 days, my lord. The full bail ground also is there, my lord, in this petition, my lord.
No, extension is already there.
Extension 181 days. On 181.
Today 181.
No. On 23/4/25.
It was already,
Already over.
but your petition was filed earlier, I think. The prayer was made. Prayer was made by the IO prior to completion of 180 days, I think.
I
No, I don't know. We at
I-
present we are not in a position to say, but
Lordship.
there may be a position, but whatever.
Lordship.
That extension is not under challenge, so we are not going to discuss all this. Except you have taken the grounds of 47 here. And Mr. Arani, renowned counsel for the petitioner, and also her.
Yeah.
Sorry?
H.A. Ahmed.
Huh?
H.A. Ahmed.
Oh, sorry, H.A. Ahmed, huh? H.A. Ahmed. Your name is not reflected here. Huh?
In the Upalatnama, my name is.
H.M. Ahmed, renowned counsel for the petitioner, and also her Mr. B.S. Crawford, renowned additional PP, appearing on behalf of state respondent. This is an application, section so and so, in connection with so and so. Full stop. It is submitted next, right? It is submitted by Mr. Ahmed that the present petitioner got arrested in connection with this case on 24/10/2024. And till that, the IO could not file the charge sheet. Full stop. However, a prayer for extension was allowed by the court on 23/4/2025. Mr. Ahmed further submitted that present petitioner is innocent And nothing has been recovered from the conscious position of the accused petitioner. Stop. The Mr. Ahmed further raised the issue of non-compliance of section 47-48 BNSS, as well as it is also submitted that the grounds of arrest were not mentioned in the arrest memo as well as the inspection memo. Again, same thing. Law court submission more or less same থাকিব.
Special judge Goalpara.
Special judge Goalpara. Special judge Goalpara. Okay. Charge sheeted case নহয় দেই এইটো, not yet charge sheeted. এটা লৈ দিম.
20.
My lord, page number 21. Your lordship's order, my lord, with regard to co-accused. This is a small when he was arrested and all those. Page number 21, my lord. This is my case, my lord, and as far as
Your arrest is, you got arrested?
same day, when these co-accused were arrested, that is on 15/1/2025.
But there your I mean possession was not there.
Possession was not there yet.
Here
Here possession is there. My lord may kindly see page number 16, 17. Page 16 and 17. Original 16, 17, 19 and 20. That's my. Yes, position, January position. These are the certified copies.
Now, see, this is the person from Manipur. Can you expect his attendance can be procured after he released on bail? Never. His attendance cannot be procured by the learned trial court below. He is from Manipur. You won't find him. That is the issue. No, I was asking you, it says arrest memo, you have brought these things, but the question is that whether this position was from you.
Yes.
Recovery was from you.
Yes, according to this, the recovery is from the FIR.
In this case, Lordship may kindly impose some strict conditions, Lordship, that for bailer, as a bailer, Lordship, one government official may be of.
We are trying, we are giving this one, but let us say they may arrange the government servant somehow in from Assam also. But we have not put any restrictions that regarding the government servant. He may be from all over India also. It's not the case that it has to be from Assam. In one petition, we have seen that he could not, arrange for the bailer because he has, obviously there may not be any person from the Assam, which is known to him, but.
In my understanding, my lord, one of the bailer should be a family member. That would be easy because landed property of a family member. This is what we do. We advise them to bring their family members because it is easy to catch the family member. Otherwise, my lord, they will arrange local bailers. That is what is happening. I know, my lord, as an officer of the court, it is my duty. But if one is a family member, father, mother, brother, then it is easy to procure the attendance. That is from my experience, I can tell them.
That may be one from
a family member,
one maybe one from government official from any.
Same time, Tufan Singh will be not there because it's recovery from his person as per him. So, is recovery the it's not a home. Okay, it is a case from same Kamrup Metro.
No, not Metro, not Guwahati.
Not Guwahati. I mean Kamrup rural Amingam.
Amingam.
Kamrup Amingam. Special just Kamrup Amingam. Okay, Mr. Not to yet a deed is by us. And the order is there only in our earlier order, Mr. But don't make Tufan Singh there. The Tufan Singh is there, but don't bring Tufan Singh.
I'm deeply.
Okay.
The petitioner before lordship was arrested on 21/1/2024. What was the name? Please, lordship may call for a scanned copy of the case record and the case diary.
Yes, when it can be called for.
See, Kamrup, my lord. Metro.
On 29th.
Yeah, otherwise it is a charge sheeted case item.
Single witness has been examined today.
29 you are saying? We'll do 29?
By the race.
অলপমান আগুৱাই দিব পাৰে।
Any?
26 can it
26?
be? 26?
Maybe.
Okay, 26.
Problem.
Scan copy.
49.
Made with the lordship, but in second bail application earlier rejected before the charge sheet was filed lordship. Now charge also framed. The petitioner is a 70-year-old person lordship. A case record may be called for lordship.
Notice.
So he is in custody since when now?
He was arrested on lordship 24/2 lordship. Whole
20
person lordship.
24
to
to
lordship.
25.
24 to 25 lordship.
25. Case has already been charge sheeted.
Charge already framed lordship.
POCSO is there lordship, notice will go lordship.
Oh, obviously, notice will go first.
Lordship.
Notice to the POCSO. Huh?
Lordship, my humble prayer is that can we fix on 23 lordship?
I know. POCSO. Sorry.
Notice will be returned. If it is, can be, I don't know,
Lordship, let us try.
23rd. You take steps by today only?
Lordship.
23rd. We are fixing it 23rd.
Lordship.
By the time if it comes okay, then otherwise, Mr. Lawford, we can do one thing, or we can also, you can take instructions from the judicial police station regarding the service.
Lordship.
If it is there, then otherwise we are calling for the scan copy of the
Lordship.
record also.
I mean, I'll say any call for lordship.
Yes, yes, we are calling it. We are calling it on 23rd.
Lordship. Oblige you.
21 of the daily list.
May I please, your lordship?
No, 21. 21 is 1 week
21 is
because prayer was made in the morning hours, I think.
22, my lord. Sorry,
20.
20.
It is 22.
21.
Sorry, 22. I marked it in 21. That's why I'm saying. Okay, then yes, 21, what you're saying.
My lord, this is a matter of anticipatory bail. Actually, this case was of Sri Bhumi, and the matter was registered on 11/1/2025 regarding an information received regarding reliable sources of carrying of the narcotic drugs, which is from Badalpur to Karimganj area. And the suspect was confessed as heroin bin of 130.52 grams. And my lord, I am apprehending arrest because I am the mother as well as the owner of the vehicle on which she was traveling. And I have annexed the copy, my lord, in page number 20, my lord. '19 and 20, my lord. Where I'm the owner of the vehicle as well as this has been recently paid, my lord, and it is already on EMI, my lord. And I was supposed to file the Zima petition there, and I'm apprehending arrest, my lord.
We can call for CD lordship because
This is
lordship.
NDPS matter, so we have to call for your involvement may not be there as a mother or as a owner. But your son is there.
My son,
He was already arrested.
he is already arrested, my lord. He is also granted bail, my lord.
Acha. Okay. When it can be called for?
27.
27.
My lord, interim, maybe.
No, here you cannot be 27.
Development.
CD college.
For bail hearing, item 23.
But in this case, my lord, by way of an additional affidavit, page, my lord, 55, 56, and 57. I have annexed this arrest procedure ground. And my lord, the I was arrested on suspicion, my lord. No recovery from me. Another ground. And LCR is there, my lord. In LCR, I have.
Second notice not complied with, Lordship. That is that I have flag marked.
I
Your
have
flag
flag-
mark.
Flag mark, my lord.
And it is the arrest is Lordship 25/6/24 Lordship.
Arrest is on 25.
6/24.
No recovery from me.
CS submitted.
Yes, sir.
What is the stage of the case at present?
Case, my lord, here in this case, the charge is not framed, my lord.
Charge not yet framed.
Not framed. It is still on production stage.
তাতে সেইটো mark কৰি দিছে নেকি? Oh, where is it go? এইটো নেকি? This is not. Oh, this is it.
এইকেইটা?
Your petitioner's name is Abdul
Jalil
Jalil.
Elias Potai.
পাঁচ করো নি?
Scan copy receipt. বাকি same থাকিব. But Mr. H.R. Chaudhary and unlock থাকিব. Arrest on 25/6/2024 CS submitted. Not yet charge not yet framed. That's what we did. Here 47 notices there, huh? Not 50. 47. Then arrest memo is there, inspection memo. 48. 48 is not there. 40 is not even complied with. 48 is not even provided to the relative oblique family members of the present petition. Non-compliance, like the same submission taken. Here also law for the case is not yet charge not yet framed, although charge seated. And one more submission, this is not nothing has been recovered from the person of the present accused petitioner, and he was arrested merely on suspicion. Etu line at koribo khali. Okay. Is this case from again Sribhumi? Patient just Sribhumi.
Number two. Yeah.
24.
Maybe.
Yes.
Well, it's a stated case, let's notice was issued to respondent number 2, my lord. Earlier occasion, it was directed to.
Oh, is there any, what the office note says?
23.
Information copy already been received by the, my informant connect.
Is
Yeah,
there
call
any
for the, madam.
instruction?
No, my lord, call for the report, madam. We have not received the report. If my lord.
Amicus curiae maybe.
Appoint amicus, my lord. But apparently they are not coming.
The notice was, the first order was on 13/3/2025.
Lost.
And they have already taken step within 23/2025.
Yes, taken step.
And office notes of 1/4/2025 says that not still awaited. So we can appoint, I think,
Amicus,
otherwise it
madam.
will be.
Amicus.
And what is
Getting
this
late.
stage? It is the already charge sheeted case or
That's it.
charge sheeted? We have received this scan copy here?
Yes,
Scan copy already received, madam.
Oh. Pardon, Mr. R. Islam, the learned counsel for the petition. And also heard Mr. MP Goswami, the learned additional PP, appearing on behalf of state respondent. As per our office note dated 1/4/2025, the service is still awaited for the respondent number 2. Though the steps were taken to the respondent on 23/2025. Considering this aspect of the case, let amicus be appointed to represent the respondent number 2. Accordingly, Mr. D. Gogoi is hereby appointed as an amicus to represent the respondent number 2. Registry will do the needful. Scan copy of the also has already been received. List the matter where it can be listed, because the amicus will also need some time.
Yes. 1 week at least.
1 week. After 1 week will do, or you want any date?
26,
26, fine. Released on 26.
File of bless.
That's not the word.
25.
Made to your lordship.
Yes.
And this bail petition is under NDPS Act, my lord.
Hmm.
My lord, contraband is heroin. My lord, it was seized from two different places. Seizure list was also different. My lord, total is 276 gram. My lord,
Heroin,
hero-
276 grams.
76 gram in total. From one place, it is 112 gram, and other from his residence, 164 gram. And my lord, he was arrested on 5/5/2024, and today is my lord 12/5/2020. More than 1 year he is in custody.
Well, there is some 5/5/2024.
More than 1 year he is in custody. My lord, the stage of the case is that my lord, the on charge has been framed on 5/3/2025.
No witnesses examined till late, lordship. So
How many? No
State
witnesses.
Witnesses not examined. So apart from the delay of trial, my lord, the lordship, no ground of arrest was furnished, my lord. Record is here, my lord. I am also having the photocopy of the notice, my lord.
that count is taken or not in the petition, or that has to be taken also.
My lord, record, your lordship has called for the record, my lord. In the record, that notice is there.
That plea has
But
to
you
be
have
taken.
not taken that ground.
I have
In
not
your
taken-
petition.
Not taken.
Petition has been taken.
Then in that case, we have the scan copy with us. At best, you can do one thing, you can file an additional affidavit in that case.
My lord,
And you annex the certified
My
copy. If you have obtained any certified copy, that can be
my
annexed.
lord, my lord.
I was taken for filing affidavit. but it-
Oh, acha. Then, yes, additional affidavit you have filed. You took time, sir.
I
Have you?
took time, my lord, but I could not file because of communication gap, my lord. I could not
Okay.
find out the relatives of the accused, my lord. And lordship grant me. By
Because those grounds of arrest you have taken, it's the notices are with us also, yeah, indeed. But you take those grounds through an additional affidavit and
my lord,
try to file your
my lord,
certified
my
copy
lord,
of it.
my lord, my lord,
When it can be, you will be able to file
29.
my lord. By next
next week,
week, next
Tuesday.
Tuesday.
Tuesday is 20. 20. 20?
Tuesday.
On 26 lordship.
Pardon?
On 26 lordship.
26. He's saying 26.
Let it.
Then release them at 26 so and so, enabling the petitioner to file this additional affidavit along with the certified copy of notices, etc. Okay, we are listing it on 26/5. You file your additional affidavit along with the certified copy.
26.
May please the Lord. Lordship, this is a certificate case, your lordship. Records will call for your lordship, since records are here, your lordship. Respondent number 2 also. Nama, your lordship. Your lordship, if your lordship may move on to the FIR, your lordship, the FIR clearly suggests that the FIR doesn't indicate that that any ground of kidnapping cannot be attached in this case, your lordship, because the last part of the FIR clearly states that. Oh, sorry.
From FIR, what do you want to submit?
Your lordship, the last part of the FIR.
Last part of the FIR.
Yes, your lordship, it clearly states that your lordship, that the girl don't want to leave the station and want to go with the accused. Your lordship. So your lordship,
Where it is? Sir?
your lordship. It's sufficient.
Acha. Unfortunately, at present, though the girl is
Yes, your
confined.
lordship, your lordship. Page 10, your lordship. Page 11, unfortunately, at present, though the girl is confined in the police, she is eager to go to the house of the accused number 1 and is threatening me. If I take custody of my daughter and take her to my house, she will commit suicide. So it itself says, your lordship, It is not a case of kidnapping. Your lordship, actually, they are known to each other, your lordship. There were some differences between the informant and the petitioner regarding some loan, your lordship. And your lordship, the girl had got some good terms since they were relatives. See, he asked the family of the petitioner not to allow her to go to their house, and also asked her daughter. Now, your lordship, the respondent number 2 also have filed a wakalat now, filed an affidavit, your lordship. And he has also said that, your lordship, out of anger, he has filed this case, your lordship. The FI clearly states that, your lordship, this is not a case of kidnapping, your lordship. The contents of the FIR, your lordship, at least the last portion says. And thereafter, your lordship, I have taken that ground.
Why she wants to go with the accused number 1?
Your lordship, the thing is that, your lordship, the accused number 1, accused number 2 has been, your lordship, absorbed of the charge in the police station itself. Accused number 1's family and the informant's family are known to each other. They are related, your lordship. Now, the father had some disputes regarding some loans with the family. And the father was also annoyed, your lordship, why this girl used to be so close with the petitioner, who is a little bit elderly too. So he informed the petitioner's family as well as his daughter not to visit their house. On that day, since he found out that she again went to their house, so he called the police and he made this case, your lordship.
It is registered on 137(2) and 142.
Actually, 137 and 142. Then your lordship, search sheet was
POCSO is
there.
added.
For search sheet, in the search sheet, your lordship, again POCSO was added. Section 8 was added.
Yes, doctor, anything, sir?
Also, hearing discussed, lordship, NCR has received lordship. Lordship, may kindly peruse the 164 statement, lordship. And her age is 15 years, lordship. Lordship, her consent has nothing to do with lordship. And lordship.
Otherwise, your petitioner got arrested on 2101.
Yes, your lordship. So more than your lordship, now 2101, that is another thing, your lordship. It is stated that the incident occurred on 21, the FIR was filed on 25. So that is another thing, your lordship. It's behind the bar for more than, now it's around 100 days, your lordship.
No witnesses examined till even evidence has not been yet even started, lordship. Evidence is not yet started, lordship. So, lordship.
Your lordship, informant is here, your lordship, informant is on affidavit, your lordship, has sworn affidavit, your lordship. And your lordship, 164 statement, after the girl is taken in custody, your lordship, she can be tutored, your lordship. The father was very aggressive at that moment. So she was so fearful that she didn't want to go to her father's house from the police station. So that can, your lordship, give us an idea, your lordship.
Yes.
May please, I am the informant as well as father of the victim. The accused petitioner, they were my relative, my lord, and there was some quarrel between the accused family and us, my lord. So my daughter, we asked again and again to my daughter not to visit the house of the accused, my lord, but the victim always related going to house of the victim, my lord. In this regard, my lord, we got the FIR. At this stage, my lord, the delivery considered was not there.
Here I have the objection also because Lordship, though the victim has given consent, Lordship, but Lordship, this is the case where Lordship, the heinous offense is involved, Lordship. POCSO is there, Lordship. There, when there is a POCSO is there, and when 164 statement has specifically implicated the offense, Lordship, that as the informant has stated, Lordship, it is something more than that, Lordship, that Lordship has, I think, and for the 164 statement, Lordship, when there is a physical relation, physical touch is there, Lordship, that cannot be compounded or any way. Lordship, and bail, not a Lordship, no witnesses has been examined, Lordship. So Lordship, let it be, let the victim be examined, Lordship. Thereafter, Lordship, bail may be granted, Lordship, because there is every possibility of tampering of evidences, Lordship. So Lordship, at this stage, Lordship, without the victim, evidence of victim, Lordship, Lordship may kindly not to allow the Lordship. Then Lordship, at this stage, Lordship, when they are lodging of FIR, they are after giving consent in a bail or in everything, Lordship, that
Your
will
Lordship,
not.
this is not a matter of
That is
consent, Your Lordship. Your Lordship, earlier, Your Lordship, the case was registered as a kidnapping case, Your Lordship. Your Lordship, just the girl went missing, he informed the police. Thereafter, Your Lordship, the girl was tutored, Your Lordship. Just insertion of a section under POCSO doesn't, Your Lordship, mean that he is guilty of a offense under POCSO, Your Lordship.
And when 164 statement, Lordship,
Yeah.
is there, Lordship.
Her 164 is very bad.
If it is 161, then we can say that it is because of tutor, Lordship. But when 164, once she is recovered, and immediately she was sent for the 164 statement, Lordship. So there cannot be any tutor, Lordship.
Everything happened on 21 itself, Your Lordship. On 21 itself, Your Lordship, she was again brought to the police station, Your Lordship. And on 21 itself, she was again granted custody to the father, Your Lordship. She was not sent to any children home or anything.
So you don't have any objection?
They are relatives, Your Lordship. Because of these things, Your Lordship, again, some other quarrels takes place, Your Lordship, in the villages, Your Lordship. Because they want to
But her
maintain,
statement 164 is not so.
Your Lordship, if
So why you have filed a case?
There is some misunderstanding, Madam.
No misunderstanding, but why you have, I mean, girl as a mohora? Why? Is it proper? If it is, there is nothing had happened. Otherwise, the statement is very bad. Her statement.
In most of the cases, Lordship will find that some petitioners will come, Lordship, and say, Lordship, that it is more than 3 years have passed, or no such it has been filed, Lordship. And because of this type of cases, Lordship, because sometimes someone lost FIR, thereafter everything has been done, search sheet filed, thereafter the victim will say, we have no objection, because of some misunderstanding, we have lost the FIR, Lordship. And every day, all the state machinery will run after that search sheet, FIR, Lordship.
I don't deny that, Your Lordship. These things are taking place taking places, Your Lordship. They used to just make an woman or a girl, Your Lordship, as a Your Lordship con, and they used to implicate someone, Your Lordship. These things are happening, Your Lordship. But in this case, Your Lordship, the petitioner is behind the bar for more than 100 days, Your Lordship. If Your Lordship let the girl will appear before the court and she will give her statement, Your Lordship.
Let her evidence be over, Lordship. Thereafter, Lordship may continue, Lordship.
Okay, heard Mr. I. Hussain, the learned counsel for the petitioner, and also heard Mr. B.S. Thakur, the learned additional PP appearing on behalf of state respondent, and Mr. F.A. Hassan, the learned counsel appearing for the respondent number 2. Scan copy of this is an application under section so and so in connection with so and so. Scan copy of the LCR has already been received. It is the same. It is submitted by Mr. Hassan that the present accused petitioner is innocent and he has not committed any such offense as alleged in the FIR. More so, from the contents of the FIR itself, it is seen that it is not a case of kidnapping, and the girl was rather interested to go with the accused number 1. Here the petitioner is the accused number 1.
Yes, Your Lord.
The petitioner oblique accused number 1. He further submitted that both the families, that is the family of the victim as well as the informant, victim as well, informant as well as the accused are related. And there was some dispute in regards to monetary transaction between the parties, and for which the victim was also not was not allowed to go visit to the house of the accused petitioner. But without hearing their, without hearing the parents of the victim, she used to visit to the house of the accused. And hence, out of anger only, the present FIR has been lodged against the present petitioner. Mr. Hussain further submitted that the accused petitioner is in custody more than 100 days post-trial. Case has already been charged sheeted, and hence there cannot be any apprehension of there cannot be any reason to, there cannot be any ground for there cannot be, sorry, there cannot be any probability of hampering or tampering with the evidence of the witnesses. First of accused being the permanent resident of his address locality, he will appear before a learned trial court below on each and every date to be fixed by the court. First of. Next paragraph. Mr. Lockhart, the learned additional PP, raised objection and submitted that this is not a fit case to allow the accused petitioner to go on bail at this stage, and there is the probability of hampering with the evidence of especially the minor cannot be denied at this stage. First. Further, he submitted that the victim is admittedly a minor at the relevant time of incident, and she implicated the present petitioner in her statement recorded on section 164 CRPC, and for which section 8 POCSO is also added subsequently by the other. Subsequently added, full stop. Next para, Mr. Hassan, the learned counsel for the respondent number appearing on respondent number 2, submitted in this regard that it is a fact that there was a dispute between the family members of both the informant and the accused due to some monetary transactions. However, both the families are related, and out of angerness and misunderstanding only, the informant lost the FIR. To that effect, he also filed an affidavit before this court. Next para, hearing the submission made by learned counsel for both sides, I have also perused a scanned copy of the record and the statement made by the victim under section 164 of 183 BNSS. From the materials available in the case diary, especially the statement made by the victim under section 164 CRPC, it is seen that she has implicated the accused, wherein she brought the allegation that the accused petitioner had improperly touched her various private parts while her statement was recorded by the learned magistrate. At the same time, it is also a fact that the victim was a minor at the relevant time of incident. So considering even if there is any compromise between the parties, I find that till the recording of evidence of the victim, the petition may not be no. I find it proper not to allow the accused petitioner to go on bail at this stage till the recording of evidence of the victim as well. In this view of above, the present petition stands dismissed. Rejected.
Wait, please, Your Lordship.
Yes.
As per order of the Honorable Court dated 23, sorry, 23/4/2025, I have taken step on, opposite party number 2. But as per the office note, service is awaited.
Lordship, can you fix it on? Anything work on the Sorted may be given also, may.
This is
so
a,
that
you
can
will,
take
we
instruction
need,
also
here
to
we
write
need the case diary or case record,
Lordship, yes. LCL also.
LCA. LCA we have received.
Already received.
Yes. Services awaited.
There.
You take instructions regarding the service. If it is not there, then we next date itself will appoint an amicus. Okay. Your petition is in custody since when?
Since 2024, 193 days is behind them.
And what is the stage of the case?
Now it is says copy for copy.
Not yet, evidence not yet
No.
recorded. Heard MS NS Takuya, the learned counsel for the petition, and also heard Mr. B.S. Locker, so and so, from the office note dated 8/5/2024. The service is still awaited for the response number 2. However, the scanned copy of the case record has already been received. Mr. Locker, the learned edition PP submit is hereby asked to take instructions regarding the service of notice on response number 2 on or before the next date of listing. List accordingly when it can be listed.
On 19th, Lordship. 19.
19.
Oh, bless.
19, let it be 19 many matters are there, in fact. Maybe 2021,
As per convener.
21. Okay, by listing it on 21.
Oh, bless.
Vicky?
CD answer. And not this CD was called for.
Yes, it is received only.
Yes.
Okay. On 2 occasions, it was not received, I think. No? Received late. Okay, okay.
My lord, I think your lordship's interim order covers everything. I did not argue the matter again. Somebody else's, my lord, Twitter account, they were trying to connect. In one of the case, my lord, the case emanating from, I think, Dibrugarh, na? Not Lakhimpur. There, my lord, the direction was given to CGM Kamru whether the case pertained to Morigaon Lordship.
Yes.
And the 47 notice was of my lord, some other police station. A lot of irregularities are there. Anyway, my lord,
So
he has-
this one is from the earlier one. Or
Yes,
it is
first
from-
one.
First one, wherein this.
That, my lord, the act of that 89 was sought to be invoked.
Yes.
Whereas the tweet does not say anything derogatory about the gentleman, my lord. In fact, the
Yes,
tweet,
I can remember. Yes.
Yes. if your lordship would kindly come to the tweet, which is at page number 52. On the contrary, my lord, something very good was said about that gentleman. He is a MLA only because of his father-in-law, who is a tax commissioner, who is respected in Lakhimpur.
Yes,
So,
I can understand.
question of invoking that provision never arise. And my lord, he has cooperated, my lord. Now his statement has been recorded. He was in custody. Now he has been released, my lord, recently on the basis of an order passed by the session judge, Morigaon. In the third case, he was arrested.
Again, in
Yes, on the after your lordship's order in the second case, my lord, there was a Hindi cinema-like situation in my lord Jagirod in that tri-junction,
Okay.
where my lord, anyway, he was arrested and he has been eventually released on bail. By
From the
session
third
judge.
case.
Third case.
Okay.
So I'll
So now
respectfully-
he is not in custody.
No. So I'll respectfully submit, my lord. Lordship will make the order absolute. my lord. I'll cooperate with the agency.
Yes, what is this here in the case diary?
Also, there are 2 cases, 28 and 31, that can be taken up together, I think.
2 cases today only.
Yes, my lord. One is from Morigaon,
So
Lakhimpur,
28
other is
and
from
31. Okay,
30.
but CDs are different, I think.
Yes, the CD, both the CDs are yellow.
Yes.
So
Okay,
that
then.
it has.
Now, see, so far I can remember one was 28 was that is the one against one gentleman regarding STSD or whatever the allegation.
Yes.
And the other one was Twitter handle was there wherein the name this vengeance or
Yes,
what
yes,
was there.
absolutely correct.
That is there.
Whereas he was seeing return was his account.
That was your submission, yes. So now it is already verified whether the Twitter account is. Now you are going to submit on 28 first?
So in both the cases, also the issues are quite similar.
Okay.
But the issues are similar but not identical, if I may say so. But regarding the phone lordship, the mobile phone which was seized, it has been re-seized in the other case lordship, in the
Yes.
second case.
Yes.
And thereafter it was sent for forensic laboratory lordship. Thereby lordship, they had issued that technology is not with the FSL lordship to authenticate the regarding the materials contained in the phone lordship. Thereafter lordship, it was sent for CFSL lordship. In yes, CFSL lordship, it has not been mentioned where it is, and the report is still to be.
CFSL Bangalore, Bangalore is
Delhi
also
or
Delhi is also there.
Hyderabad.
Hyderabad or Bangalore somewhere I think. It was.
Verify and submit lordship, but that report has not been received as of yet. So lordship, that part has not been verified as of yet. Lordship.
No, you need one thing. In the other one, this is 31. 31, we need some verification whether that the his
Yes.
seeing return
Yes.
was his or that other this the vengeance or
Yes.
whatever it is
Yes,
was there.
yes, lordship.
So that has already been verified because on the last day must be to 31 to the one.
31 lordship, the note says the mobile handset seized from the possession of the so-and-so has already been forwarded to the CFSL in connection with Lakhimpur case, in the other case.
Lakhimpur is,
Yes,
Lakhimpur is the first
second.
case.
Yes, yes.
First. I'm sorry, first.
Yes. In view of the aforementioned procedural development, I am presently unable to take the seized mobile phone into my direct custody. So in this case, that mobile phone could not be taken into.
But it was re-seized, I think.
Order was given lordship, but lordship that it is mentioned in the IOS note itself lordship. Nevertheless, in the interest of further investigation, I have proactively transmitted the URL of the social media account, specifically the X platform, the Twitter handle lordship, allegedly operated by the accused person to the concerned service provider for the purpose of authentication and verification of the ownership and users of the said account. Additionally, I have to formally requested the relevant authorities of the said platform to ascertain whether the accused person is linked with or has operated any other accounts on the X platform that may have been used for certain. So that report has not been received. Lordship.
So that means the FIR was based on some supposition.
At this stage, if lordship permits, we can update the case that in the report lordship, if lordship permits.
Now, see, to be very frankly saying, in the first case, I don't know whether the one
Yes.
father-in-law was some was there.
Yes.
There was, if you go by that tweet, there already Mr. Chaudhary has narrated. This one there too. I didn't find any derogatory words or communication, anything. In the first case means in 28. 28 is of Lakhimpur, I think.
Yes, Lakhimpur.
And the other one, I don't know. Other one, there maybe they need some verification. Maybe they need a verification. Maybe there, but the 28, whether you have to anything to say.
28
because it is not the case that it is most probably not disputed. Also, that tweet was from his account. It was not disputed. But
next day, tweet Annexure 7.
Annexure 7 in which matter?
28. Item 28.
Item 28.
Page 919.
Oh, 919.
Page 52. 82. Same one below. Page 62 and 52 is same.
Yes, this is the tweet, I think.
Yes, that is the tweet.
So here you want to submit
the lines also the last paragraph. Not even a stray dog would so and so also. That is contained there also. That is the allegation.
Now, how state is aggrieved by this portion? It can somebody, a private individual can be aggrieved. Well, the other day, the Supreme Court has said, my lord, that MP from the ruling party, he said so many things against Chief Justice of India. Chief Justice of India says, your saying will not denigrate our institution. So that is the spirit in which things are being taken, my lord. The other day, my lord, Bombay High Court convicted a lady advocate. Supreme Court has stayed it. Look, gone are the days, my lord.
Look, now recently Honorable Justice Oak and Ujjal Bhuiyan has delivered a judgment where it says even in a pending matter, constructive criticism is welcome. Because Milord, Article 19(2) is not the rule, it's an exception. Rule is Article 19(1). Therefore, yes, it could be addressed as defamatory. Where is the question of, criminality in this case, Milord? With all respect, I'll submit. Assuming this is correct, a state cannot be aggrieved by this. If state is taking up the case of somebody, then it is. Otherwise, state cannot be aggrieved by this part.
In FIR, most probably this allegation of the, because the father-in-law of this other one, the other person, is the belong to most probably ST, no, not ST community. So that is there. But if you go by the tweet, the ST community is not, is there any derogative
Nothing.
word against him?
No.
Yes, one last para is definitely not even a state or whatever is there.
But that gentleman is not before a lordships. That Deka gentleman is not the informant. The informant is wife, who happens to be scheduled caste because of her father's connection. But via father, there is nothing. On the contrary, he said he is a respected man of Lakhimpur. It is her perception, my lord, in the FIR. It is her perception, it is her comprehension that this may be so and so. And the lordship knows the circumstances. That was a blank FIR she was carrying, the police was carrying without any signature. Subsequently, when the FIR was registered, date was put. I've shown the other day, lordship recorded in the earlier order.
It has been recorded.
FIR has been filed by Rajushi Sotia, wife of Manav Dekha. And their lordship in paragraph 5 in the FIR also, saying that a notice paid would vote for him. Isn't that lordship derogatory lordship? Saying something about her husband. Lordship will find a paragraph 5 itself, page 50.
Yes, that is there.
That is the case, lordship. Now the case is pending for lordship, the CFSL report, lordship.
So what is your submission? You want to make it any disposal order or want any further?
Lordship, they are already under interim. So let the report come, lordship. In the meantime, we will verify, lordship.
That means in both the matters, the report is awaited.
Yes. That is my limited submission, lordship. Let the report come, lordship. They are otherwise outside only, lordship.
Now at last you are outside.
That is there, my lord. Regarding the first case, my only legal submission is, my lord, assuming this statement is defamatory. So based on police report, a criminal defamation
That day also you have submitted in.
Therefore, my lord, so the FIR is absolutely without any, legal sanctity. Anyway, my lord, if they want to verify, let them. But I think the first case lordship could have closed today.
That's what I am asking Mr. Sharma, but he is saying that's still awaited. I'm not on the second case. Second case, definitely the verification is required because one is there. Whether it is from 22.
Same date, lordship, along with the CFSL report. And if it doesn't come, lordship, then lordship will pass for the lordship.
CFSL report.
Let it come, lordship.
In the both the matters, more or less. But you are in the second case, you are saying that it is not yet received. Then again, how can we await for this one? Or?
There are some difficulties, lordship.
So in the first case, we need not wait for that, my lord.
No, he is saying in the both the matters, this matter has already
but
been.
The fact of the matter is it has been seized in the other case. In this matter, there was no seizure, therefore it's not required. Here, what they want to verify, the Twitter handle only, my lord.
Yes.
Yes.
No,
Twitter... and my lord, the Vitam Singh, the Twitter handle from which I made this statement, those are before lordships. Whether that is defamatory or that constitutes any criminality. That is the only aspect lordships will look into.
So here,
yes,
the case that which is before a lordship, their lordship has already seen that the phone has been received, but the phone is not in the physical possession of the IO lordship because it has been seized in the other case. And also, lordship, the Twitter handle has also been, the IO has been trying to verify it, lordship, regarding the Twitter handle, lordship. So in that case, lordship, let these two cases come up in the same date, lordship. No harm will come to the petitioner, lordship, because he's already here. And on that day, lordship will verify, lordship, what has happened.
Already enough harm has been done.
Let it come on the same day, lordship.
So as a whole, your petitioner is in custody takes how many days?
My lord, I think almost 2 months.
Okay, then Mr. Sharma, you insist on that, we'll keep it a fixed date for both the matters. But otherwise, I'm against insisting on the first
Yes,
matter
yes.
that is on 28.
I understand.
If you go by the things, it is already there. The
Yes.
second matter, definitely, their
Yes.
verification will be required.
Yes.
But in the other one, it's 28,
Yeah.
may not be required. Anyway, heard Mr. Duita order same Kuitaba, heard Mr. K. N. Chaudhary, the learned senior advocate, assisted by Mr. H. Buragohan, the learned counsel for the petitioner. Also heard Mr. B. Sharma, the learned additional PP, appearing on behalf of state respondent. It is submitted by Mr. Sharma that the CD is received, but from the note of the FI as well as from the materials available in the case diary, the report is yet to be collected from CFSL, which has already been sent by the IO during investigation. What same order we do? Accordingly, he submitted that updated case diary may be called for along with the CFSL report. A report full stop. Considering the submission made by so-and-so, CDP may be returned, calling for an updated case diary along with the CFSL report if collected by the IO. Yes, it may take some time. Yes, when it can be fixed?
3rd or 4th of June.
3rd or 4th of June? 3rd or 4th of June. Till then, the interim granted to the accused petitioner be extended till next week. Date kita di 3-4. 3-6, sorry, 3-6. Itu hasil untuk naik pahari itu. Nanti itu hasil itu. 3-6 na gitu. Kata mati depan. This will be the last one.
29.
Yes,
In this interim is granted, madam. Or the
Considering the health condition of the
considering the health
petitioner,
condition.
he was released on interim bail. So updated city was called for on 10-4.
But my lord, regarding that matter, only the bail objection has been given, madam, update, but the CD is not updated. But
Because we passed the order on 10-4.
10-4.
Is there any updation there?
No,
Nothing.
my lord, 25-3 is the 25-3. So let it be updated. Otherwise, materials are there against.
Lordship, the
So court wants to know the present investigation on that date. madam.
Pardon?
In the
Pardon?
earlier date, madam.
Ah.
Since the materials are also there, madam, so court wants to get the status, madam.
Because
Up to
the
that
interim was
status.
granted because of his health condition, in fact.
It's called for.
Yes.
The entries again in March.
Mr. Mahajan is also appearing.
Yes,
Yeah.
as
Amicus
amicus,
was.
madam.
Amicus.
From March, madam, it is.
Lordship, on the bail order was passed on 10-4, Lordship.
Yes.
He could be released only on 19-4 because of the holidays, Lordship.
Oh.
After release on bail, he was admitted in hospital on 22nd, Lordship. 23rd, he was released. Subsequently, Lordship, he was suggested certain oncology report, it tending to be, with my limited understanding, Lordship, tending to be cancerous probably. So the condition is not.
Now he is taking treatment any in
Lordship,
oncological department or?
He's going to Department of Tasteful Cancer Center. He has already consulted Lordship. They have given a report. So I have all the updated report, Lordship, and
Regarding his data.
health.
So you can submit these things. Just we note down it because as he has already been taking treatment.
Lordship, or I can file an additional affidavit also, Lordship.
Yes, it can be. It can be
And
In the
with
meantime, we
the,
can call for the update.
updated one.
the subsequent medical document, if any, Lordship.
Yes, definitely.
And Lordship, the otherwise, what I have been instructed, Lordship, the grounds of arrest also, though I have not taken the grounds, Lordship, in the petitioner, grounds of arrest is also not communicated, what I have been instructed, Lordship.
He may bring it on record.
Through an additional affidavit, those matters can be bring out in.
Lordship.
Heard Mr. D. Das, the learned counsel for the petition. Also heard Mr. M.P. Goswami, the learned additional PP appearing on behalf of state respondent, and Mr. N. Mahajan, the learned amicus curiae for the respondent number 2. Next, it is submitted by Mr. Goswami that the CD received, but it is not updated one.
No.
And there is no entry from 25/3 is the last entry.
25.
The entry in the case record, case diary from 25/3/2025. Accordingly, he submitted that updated case diary may be called for. Full stop. In the next para, Mr. Das, the learned counsel for the petitioner, also submitted in this regard that after obtaining the order of interim bail, the accused petitioner consulted doctor, and now he is in under treatment, and he was directed to consult with the oncological department. Mr. Das accordingly submitted that he will furnish the detailed medical report on or before the next date of listing. It will correct the video, CDB return, calling for the updated one. List accordingly. Yes, Goswami.
Next date, my lord. From Musa, we have to send back the CD.
Yes, give us in long date also, because he is in treatment also, under treatment.
Month of June, my lord.
Month of June.
June, any date.
Any date? 9/6. 9/6 window. Okay, 9/6. Interim be continued till next date of listing.
I'm August.
Oh.
Petition 4 of PD4 pertaining to Itanagar bench.
Yes, I have partly matter is heard, I think, na?
Yes.
Right, so,
I have noted down your submission also here.
Yes.
So again, this is a petition for maintainability issue raising.
Maintainability, in fact, basically, this application we have filed, Lordship, under Order 6/16.
Yes.
Lordship, may the I to 10. I. This IA is basically under Order 6/16.
On the last occasion, Mr.
Yes, Lordship.
Yes, it was submitted that Mr. KP Pathak will be arguing this matter, or
Lordship,
or you are going to. No, if you are going to argue, we are here to ready to hear the matter.
Lordship,
you are appealing for the petitioner or the respondent side. I mean, the election petitioner or the respondent.
For the election petitioner, Lordship, as of now, there has Nalopada sir, he is appearing in the matter. He is on leg on another court, so I'm appearing on his behalf. I mean, in fact, I'm appearing in this matter. So far as the instruction from the election petitioner is concerned, so there has not been any instruction regarding learned senior counsel, so that we have to seek further instruction in that in this regard. So the applicant, Lordship, I have been told that on the last occasion it has been part heard. So the Lordship, the applicant may conclude his argument, and next date may be fixed for reply on our side. Yes.
In fact, today I'll be requiring about 2 hours of time for completing my argument.
2 hours?
At least 1.5 hours. And if your Lordship thinks there are some bail matters which are also listed before your Lordship, you can take up
Today?
30 I start. Today I'll complete.
Because on the last occasion you have submitted, those were already recorded.
Yes. There are 2 categories of allegations in this case. The first category.
Okay, then if you take time, okay, then we can finish it up the bail matters. Some bail matters are there.
Well, that's what because once I start, it will take minimum 1.5 hours. Because today I'll be citing those judgments also. So it takes some time. Because there are 2 types of allegations. One is undue influence, and second is boot capturing. Undue influence part in paragraph 13 of the election petition, I have completed my
Yes,
argument.
yes, I have already noted, yes.
At 12, para 12. And para 13, they have made allegations about booth capturing.
Hmm.
Not many paragraphs, 4 or 5 paragraphs. So
Hmm.
once I complete that, my oral submissions, then I'll go to the judgments which I am relying on. So Lordship, in the meantime, complete
Yes,
this
okay.
bail matters.
Okay, then we'll may connect with you by 3. Or, I mean, will do you connect? Yes, we will informing you. We'll be informing.
Lordship,
After the bail matters are being over, then we'll issue it.
Lordship.
And he may we may heard Mr. Mozumdar's part today, and then only. Okay.
Lordship. Deeply obliged.
Okay. Then 30. Yes.
On the case of register 22B, my lord, and they were arrested, Lordship, 12 March 2025, my lord. Now
12th of March.
25, my lord. Now 60 days already over.
72 days is 72 days, Lordship. Oh,
Before
not
pay.
yet charged it?
Not my lord.
Not yet charged it. 72 days. No, not 72
62
days.
days. 62 days.
62 days.
62 days.
And have you received the case diary here? CDS. Otherwise, there are some materials. Heard Mr. J.U.M.N. Loskar, the counsel for the petition. And also heard MS and Dust, learned additional PP appearing on behalf of state respondent. This is an application on the section so and so in connection with so and so. It is submitted by Mr. Loskar that the accused was arrested in connection with this case on 12/3/2025, and thus he has already already passed his statutory period in the jail hazard, but till that the IO could not file the charge sheet, and hence he entitled for default bail. MS Anders the learned additional PP submitted in this regard that there are sufficient incriminating materials in the case record. However, it is a fact that in spite of the lapse of the statutory period, the charge sheet could not be filed by the IO. Have these these things have been collected? This FSL report?
Sure.
Not yet. Further submitting that the FSL report is not yet collected by the IO. In view of this, without going into the merit of the case, only considering the length of detention, the accused is hereby allowed to go on bail, so and so quality. To whose satisfaction it has to be?
District हो जाए.
District हो जाए. Special judge supported never हो जाए. Okay, will be disposed of bail.
हो जाए district. Oblige.
32. So CDI is in there. Then it will take time to still that to my switch off for the by tomorrow.
Wait, please, your lordship. Lordship, the petitioner is behind the bar for 230 days, my lord. The charge sheeted case.
230 days.
30 days, my lord. And the case is charged under section 6 of POCSO Act.
Here, we have anyone is appearing here?
My lord.
Services.
And on last occasion, my lord, the.
Yes, it was asked to take steps.
Instruction from the police, my lord.
Mr. Kaushik was asked to take necessary instructions. Office note to PSN.
It's not, my lord, services awaited, it is saying that.
And copy is not received. Service is also awaited. At best, we can do one thing, we can appoint an amicus to make it delay, I mean, to cut the delay, hard. You are Mr.
DK Mehdi.
DK Mehdi, the learned counsel for the petition. And also heard Mr. MS Andas, the learned additional PP, appearing on behalf of state respondent. As per office note dated to 8/5/2025, the service is awaited and the scan copy of the case record is also awaited. The full stop, the registry is hereby directed to issue reminder to call for the scan copy of the case record. Further, the amicus may be appointed to represent the respondent number 2 as the established report is still awaited. Post hoc. Accordingly, Dr. P. Agarwal is hereby appointed as an amicus to represent the respondent number 2. Registry will also, but registry will do the issue reminder for us, then I'll get it in. List accordingly when it can be listed there.
On 26th version.
25th,
26th.
26th window, 26. We're listing it on 26. One amicus already been appointed. We will comment.
Hello.
33.
It is the lordship. In this case, I'm in custody for last 584 days, my lord. I was arrested on 7/10/2023, and it is, my lord, 1 year, 7 months, 6 days. Charge sheet has already been laid in this case, my lord, and only on 5/5/2025 charges were framed, fixing the matter on 22/05/25 for recording of evidence, my lord. But so, my basic ground before the lordship is to consider the notices which has been issued. I have flag marked the same manner in the trial court record with a pink flag, and based on the violations of section 50 CRPC, lordship was also pleased to release one of the co-accused by order dated 3/4/2025. Pink flag lordship has got it, madam. That is the notice.
Your petitioner's name is?
Yes, Gyashuddin, madam. Pink color flag mark at trial court records is there, madam. Here, 50 notice only reflects that intimation of arrest was shared with the present petitioner, madam. And based on this, lordship was also pleased to consider the co-accused bail application, which I have annexed, madam, at page 38. He was also in similar patient, madam. Notice was issued to him, Abu Bakr. And because it's a violation of 22(1), that with 50 CRPC, lordship was pleased to release him on bail. Madam, I am also saying similar consideration at this stage, madam. I'll face the trial with any conditions if lordship kindly considers my condition and liberty at this stage, madam.
Your petition, the other one was arrested on
same, madam, on similar, on same date.
7/10.
Yes, madam. Lordship's order is very much clear on it, sir.
So charge frame only on 5/5.
Yes, madam. 5/5/2025, madam. It is on not on record, but I have, madam, through my junior colleague over there, I have confirmed, and they have also shared, madam, that it was recorded, uploaded in the kiosk, madam. I could not get a printout, madam. That is right. But lordship can record, madam. It is 22/5/2025 fixed for evidence, madam. 22.
As per the record, 5/5/25, consideration of charge.
On that date, charges were framed, madam.
এটা মই মাৰ্ক কৰি দিছো এই লাইনটো আপুনি নালাগিব ইয়াতে আপুনি দিব 132 so and charge has already been framed, charge framed on 5/5/2025 and the next date of for recording of evidence is fixed on 22/5/2025. Does, full stop, does till date. There is no, the trial has not been commenced. And there is an inordinate delay in commencing the trial. Yes. The HR Chaudhary is here, MA Chaudhary will be here, and MS Andas will be here. Here, our the submission from the state respondent have already recorded, and there are submission from on your count also, that though there may not be any written communication of the grounds of arrest, but obviously the verbal communication was there, and they were aware about the so and so. At that apart, the record of 37 is also discussed. So same submission will be there. This is also case from Shivu.
Yes, ma'am. Okay. Satisfaction of
Special
procedure.
justice.
Deep of the judge.
Default order mana ni kita ada.
Lordship, I don't know, this matter kindly be fixed tomorrow, Lordship. Yes, voluminous one, Lordship.
34.
Tomorrow. Please tomorrow. Tomorrow we use it. So to could not peruse the case record at time. The voluminous one. Tomorrow is. Okay, we're listing it on 40.
Yeah.
It may be used.
Lordship, repeatedly here I am taking the plea of count of arrest.
We did not receive, Lordship.
Lordship, because CD was called for, because your Lordship reserved their judgments, the court red-handed. That is why CD was called for. Otherwise, I have submitted the certified copy of the arrest memo and 47 notice, Lordship.
Yeah,
Kindly, yes, certified copy.
No, the arrest memo is here only, or
I have also, yes, there also. Case number. 18 and 19.
certificate copy do you have?
Yes.
Your petitioner's name is?
It's Hafidul Islam.
Safidul Islam.
Shafidul Islam.
Yes, sir. $47.
Yes, any other submission?
Yes, Lordship, other submission, this case is still in investigation stage. Charge sheet not submitted, Lordship. Yeah.
The petitioner got arrested when?
Yes, Lordship. 08/12/2024.
Not yet charge sheeted. So here recovery, and in regards to recovery, what is your submission?
As per my submission, nothing was recovered from his possession.
So it is from your position.
Yes, Lordship.
The
As per the
recovery was
affair.
from your position.
As per the affair. Because I am not on that, Lordship. I am on the.
Court red-handed issue এটা discuss করা আছে না? We have discussed. The court red-handed issue will come here. Yes.
They are discussed. The court red-handed was discussed, where the Lordship granted bail. In my case, Lordship.
We have. We have this. Heard Mr. Ajit Ahmed, the learned counsel for the petitioner. And also heard Ms. M.S. Andas, the learned additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted by MS Das that the CD not received. Post up in that context, Mr. Ahmed, the learned counsel for the petitioner, submitted that the present petitioner was arrested on 8/12/2024 and case is still under investigation. Post up charge it is not yet submitted by I. He further submitted that there was no recovery from the conscious position of the present accused petitioner and petitioner full stop. Mr. Ahmed raised the issue of non-furnishing the ground of arrest while issuing the notice under section 50 CRPC as well as 47 BNSS as well as in the arrest memo. He further submitted that the notice under section 48 BNS is not even provided to the family members of the relatives of the present petitioner. Same Next, in this context, Ms. M.S. Andas, the learned additional PP, submitted that the present petitioner was apprehended, caught red-handed, and the contraband, that is 1,000 numbers of Yaba tablets, suspected Yaba tablets were recovered from his conscious position. Baki in the same packet, Amar Restro 37 report will follow, and the caught red-handed issue we have already discussed, put these issues on. Okay.
It is sitting from the special just South Salmara Mankachak.
South Salmara Mankachak.
Lordship, we have service report awaited.
It's a POCSO.
POCSO, Lordship, section 8 is there.
We have received this scanned copy, services awaited.
Yes, Lordship.
You have taken steps on 34.
Yeah.
Okay, then to cut the delay, we will appoint a man amicus here. Heard Mr. Arhok. Heard Mr. Arhok, the learned counsel for the petition, and also heard MS Andas, the learned additional PP, appearing on behalf of state respondent. Scanned copy of the case record has already been received. However, from the office note dated 8/5/2025, it is seen that the service is still awaited for the respond number 2. In view of this, let amicus be appointed to represent respond number 2. Accordingly, MS and Mr. N. Mahajan is hereby appointed an amicus to represent the respond number 2. Rest you will do the needful. List accordingly when it can be listed.
On Lordship 23rd.
23rd? Oh, 23rd.
CD not received, Lordship.
CD not received. It's from Hatigaon. Yes, it is from Hatigaon. When you can be 19 also matters are there. 16? No, we are not fixing on 16. Less numbers of people because some reasons are there, so we are not fixing on 16. Maybe 20, yes, 20 can be. CD not received. Issue reminder, list according to 20. 20 we are listing it.
50 of the supplementary list.
5-0. Itu কি বস্তু এটা?
Lordship, please.
My student start for deployment. That has informed me that the respondent has received a copy and they are partly vocal. The respondent. Informant.
For informant.
Yes. First, my appearance in district. So they have already. Yesterday, 5 minutes. They have engaged in.
So now you want to submit on this, or is there any, you want any? No, he is going, he will submit from you, your submission. No, objection, you verbally, you will submit your objection today itself.
I have no copy in my petition.
Then how will you submit?
Yes. Can we fix another date, my lord?
That's what I was just asking you, whether you want to submit today or what.
Friday, my lord.
No, not Friday. Friday not possible. Maybe by 19
Yes, sir.
it
They are
also not
starting-
possible. I think.
We have received the CD.
CD is received. Can it be retained till 2021? Mr. Fukon, we don't have, because they are going to submit, I think.
Since I've already completed till today 50 days. Section
50
10,
days.
Yes. If it
Section
is-
10.
Section 10. 60 days.
This
is-
one can we, can you
Can
submit
it be, if not inconvenience to your court, can it be on Friday, if it is not an inconvenience?
Friday? How many?
Then I agree with you,
Friday,
Lordship.
we
Whatever is
have some,
convenient to your Lordship, because
we have some actually.
I understand.
Issues are there. Friday, we're listing just Friday morning. These fixed matters. Fixed. Fixed only 2020. কি করবো এটা? বহুত প্রশ্ন আছে। আমরা সমস্ত মানে আছে। কথাটো হৈছে we are living on 17 ওলাই যাব লাগিব। 17 is not possible for me to ইয়াতে আহাৰ sign কৰাৰ কাৰণে। আপুনি এটা ইনফৰমেশ্যন দিছে তাতে? মই দিছো অলৰেডি। কথা পাতিছো। Yes, এইটো
May I request your Lordships, it's not. Can it be, I mean, I've served him a copy, if there is no objection to him, can we keep it as
After some
last,
time,
after some time, if it is not inconvenience to your Lordships?
No, we have some election matter from
Oh, I see. Okay.
three we are going to start.
Then I leave it to your Lordships, I completely leave it to you. My only concern is the mandatory period will be over, that's all, the rest I leave it to your Lordships completely, I have no
On
problems.
Friday.
No, I think my Lord have already a very
We
heavy
have
bench
some
on Friday.
bৃহস্পতিবার পাই মনে 15th.
I won't take too long, my Lord. That's-
Just to check,
I will be extremely grateful.
15, no? 15.
15,
Okay.
Lordship.
Somehow we are meeting on 15th.
I'm
1
extremely
5.
grateful. Extremely.
Well, my appearance will be recorded.
Yes, we'll dispense it.
15th, my Lord.
Yes.
Extremely grateful.
I heard Mr. R.B. Fukon, the learned counsel for the petition. And also heard Mr. M.S. Endas, the learned additional PP appearing on behalf of state respondent. Post-op, Mr. D. Gogoi was appointed as an amicus on the last date, but the respondent number 2 has already appointed Mr. Kalita, M. Kalita, and accordingly, the appearance of Mr. D. Gogoi is here, the learned amicus is here by dispensed with. Mr. Kalita has submitted that he has already filed his Bakarat now and need some more time to file their objection. List the matter according on 15th. 15th. So
I'm extremely grateful.
okay. Right. But 15 civil matter is there, so that will take time. Sir. Okay, we are fixing up.
I'm extremely grateful.
Dash is submitted, Lordship.
Yeah, Lordship, petitioner on interim. Petitioner on interim,
Your petition is on interim.
my lord.
Dash is submitted.
Charge number
2/25, dated 2/25,
acha 2/25 acha
dated 31/03/25.
31/03/25. Okay, how many petitioners are here? Two petitioners. Both of them are on interim? Do both.
My lord.
Interim be extended till next date of 15 days interim. So we are extending your interim 15 days. By that time, you can appear before the learned trial court below with a regular application for the.
God bless you.
39.
You are on interim.
Yes.
CD not received. Issue reminder. Interim be extended till next date of listing. List accordingly when it can be listed. 29/5. We are listing it on 29/5. Your interim will be extended.
40.
Please, Your Lordship.
CD not received.
Also, in this case.
Here also you are on interim.
I'm interim. Earlier Honorable Court issue reminder, but CD not received till today, my lordship. The strict direction will be given. And 4 times I am appeared before this.
These days, actually, we cannot blame the police personnel. Also, they are busy with election purpose, I think. That's why in some matters we have not received the case diary. Anyway, issue reminder portable with a direction to the investigating officer to file, to furnish the case diary on or before the next date of listing.
29.
List accordingly.
29.
29/5/2025. Interim be extended till next date of listing.
Highly of this.
41.
My lord, is the pre-arrest bail application.
Lordship,
Since the lordship order, the accused has appeared before the IO, and even the bike has been recovered by the Adequate police station. My lord, lordship is CD.
Up to the CD is required. Statement is not available in the case.
Your statement is done. You got the interim when?
Interim on by lot 17 March.
17 March.
Yes.
Here, dear, your thing is updated till when? Because the interim was on 17/3.
10/3.
Oh, actually. We are extending your interim by that time because we will call for the updated one because the last entry was on 10/3 and your interim was on 17/3. So your, statement is not available there in CD.
Early occasion, in fact, they produced before the score, and lordship allowed them to go for updating the case ID. It is the third time it is listed. Anyway.
Updating?
In the last occasion, lordship.
Yes. Last occasion also same order was there. Why in spite of that?
Sent 2 times intimation on 10th
should
and
not be.
18th from our office.
Otherwise, the bike has been recovered by the Adequate PS.
Hard Mr. HL, the total number was so and so. The learned counsel for the petition. And so hard MS and thus the learned additional PP appearing on behalf of state respondent. It is submitted by MS Dust that the CD is received, but it is not updated case diary. And the last entry in the case record is on 10/3/2024, 25, and accordingly she submitted that updated case diary is required as the statement of the petitioner is also not in the case diary. Post. Let the updated case diary be called for, and it from the record it also reveals that on 10/4/2025 updated CD was also called for, but in spite of that the IO did not submit the updated one. Accordingly, the IO is hereby directed to furnish the updated case diary on or before listing. List accordingly 29/5/2025. Till then, it may be extended. Okay. 29/5.
On one prayer, last occasion also he appeared. Statement is not recorded. So if your lordship direct the IO to take my statement. So that
your statement is not recorded.
We appear before the court, before the IO. Perhaps it is not recorded. We have given a statement, but the record is not shown.
So you have not appeared before the IO.
We appear in the last occasion. We appear.
Further, the petitioner is hereby asked to appear before the investigating officer to record his statement, if not earlier recorded.
Yes. Give the order.
42.
Lordship, kindly this matter take up tomorrow, Lordship. PS law, additional PS logger has gone through this matter, but due to some urgency here, it's too late.
Tomorrow already matters of May not be possible. Are you on interim? Are you on interim? No,
On Monday, Lordship.
Monday.
The
They are
records-
saying that the CD is available before us, but pardon?
PS Local, Lordship.
Or BS Locker. He is not here now.
Due to some urgency, he has to leave.
Then on 15th,
15th is not possible, in fact.
Monday. will be.
on Monday.
Monday then,
On
19th. 19 corridor at the request made by the learned additional PPMS and thus they let the matter be listed on 19/5/2025 till then CDB retain. So we are retaining the case title instead.
Obliged.
Oh.
43?
Yes.
Your Lordship. Lordship, anticipated bail application, Lordship.
Yes.
I was on interim and accordingly appeared before the IO.
CD received statement recorded, Lordship.
You were earlier on interim.
Lordship. Appeared before the IO, Lordship, and my statement has been recorded also, Lordship. Acquisition, Lordship, under the betting and game and betting rights.
Pardon? Name?
Not the name against of the umpire rules.
He is the Gabura, Lordship. He is the consent to conduct it.
Oh.
In my locality, Lordship. I am from Arunachal Pradesh. It was the hell as per the umpire also. It was in the district of Dhemaji, Lordship. Within the state of Assam.
Then he is come from where? Which district? From Dhemaji?
No, Lordship. It's in Likavali, Lordship.
Likavali, Arunachal.
Pongko.
Yes, any other submission does? Heard Mr. B.K. Gogol, the learned counsel for the petitioner, and also heard M.S. Endas, the learned additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. To stop, next file submitted by Mr. Gogoi that after obtaining the order of interim pre-arrest bill dated 1/4/2025, the present petitioner has already appeared before the IO, cooperated in the investigation, and his statement is also recorded under section 183 BNSS. Mr. Gogoi further submitted that he is still ready and willing to extend his cooperation in the further investigation of this case if he is granted with the privilege of plea. Next paragraph. MS thus, the learned additional PP also submitted in this regard that the accused petitioner is cooperating in the investigation of this case and his statement is also recorded accordingly. However, there are some incriminating materials against the present accused petitioner. Next paragraph, considering the submission made by learned counsel for both sides, materials in the case diary, and the conduct of the accused petitioner, I find that custodial interrogation may not be required for the interest of the investigation. Absolute query 1/4/2025. Okay, your 1/4/2025 is we are going to absolute.
Deeply obliged.
44?
Lordship, 44, we have received the wrong CD, Lordship. This is PS
CD.
case number 3/25, we have received 3/24, Lordship.
Oh.
Next week, man.
It has to come from which district? Yes, Kamrup or Gwalpara? Next will be which? Gwalpara, 19, 20, 21. We may get the
On 20, Lordship.
20. Heard Mr. A.M. Bora, the learned senior advocate, assisted by Mr. V.A. Chaudhary, the counsel for the petitions, and also heard M.S. Endas, the learned additional PP for the state respondent. It is submitted by M.S. Das that the wrong CD is received from the investigating officer Accordingly, she prayed to call for the proper case diary. Issue reminder accordingly. Yes, when 22-0?
20.
20. 20, so and so. You're not on interim, I think.
I'm not.
20 realistic.
Obliged. 46.
As per the court's order, I appeared before the IO on 18/4.
CD not received.
CD not received.
By the record.
You are on interim, I think.
I mean.
Heard Mr. A. Cabra, the learned counsel for the petition, also heard MS Endas, the learned additional PP, so and so. CD not received, issue reminder. List the matter accordingly, yes, so it can be.
On 28, Lord.
28.5, 28.5, so and so. 28.5, 28.5, 2025. Interim be extended till next date of list.
7.
May please, Your Honor.
Yes.
You know, I filed for implementation of party respondent number 2, that is the informant. Yeah,
It's a case of related to POCSO.
Yes, Lordship. In a matter, Mr. I may not made party informant, Lordship.
Achha.
Informant is the brother of
She is the mother.
brother.
Brother.
Brother of the victim, Lordship. She Dhananjoy Das.
47, I had to click you, heard MS, your
A. Begum.
A. Begum, the counsel and the counsel for the petitioner. And also, you don't have any objection. A does, and does the learned additional PP appearing on behalf of state respondent. This is an application praying for implement of informant as a respond number 2. Respond number 2, full stop. It is submitted by MS Begum that inadvertently the respondent informant was not implemented as a respond number 2 in bail application number 1328/2025, and hence the present petition has been filed for implementing the respond number informant as a respond number 2. MS Endas, the learned additional PP, raised no objection. Accordingly, the present interlocutory application is hereby allowed to implement the informant, public mother of the victim, as a respond number 2 in bail application number 1328/2025. The I is disposed of accordingly. Etu yate dibo paribone teloke kenake pai main question notice to dibo laibo. And now her name, how can it be done? Her name is not here now.
Petition, this I is petition. That will be part of this.
One additional affidavit true. Otherwise, you have to amend the petition, the bail application, the cause title has to be amended otherwise. Because she is not the by nowadays handwritten is not allowed. Handwritten is not allowed. So within we may pass the order that but can I get where a 9? Huh? I is allowed. I is allowed. No, but it has to be just some order, no? The first title video card people. Main petition of take up a bail application 1328 in view of order passed in I criminal 452/2025. The petitioner is hereby directed to file amended cause title implementing the name, the respondent number, implementing the informant as a respondent number 2. after filing of the amended cost title, the petitioner may also will be at liberty to take steps for the response number 2 through judicial jurisdiction routed to the office of the registry and the public prosecutor. So we are allowing you to do, and in the meantime, after taking, you can take steps also. That is also allowed today itself, okay? To cut the delay, in fact. So we are then, in that case, we are listing your case. So here we need the case diary or LCR. It's a charge sheeted case. Also call for the LCR. Scan copy of the LCR. And is the matter accordingly. We may take some time, I think 23 or 24, I think. 24 is a holiday.
26.
30, no, he's inside the jail. 23 can be?
23.
23, fine. Okay, 23. You
For the
file the
LCR.
amended cost title,
Yes.
and thereafter you take steps also.
Yes, yes.
That is liberty is given to you.
Also from especially the POSCO Kamur Metrology.
Yes, we are calling for it. VST will do the name. Oh.
For others,
I'm actually good. This matter is completed. So connect to like I just call the item in there.
for others, IA 56 of 25 pertaining to Itanagar bench.
Connect for you, did you? Connect one, I need it.
Probably they need to.
Yes, they already connected. Yes. Oh.
Yes.
Yes.
Your lordship was.
So you one issue you have already this para 13, I think, or
Yes,
13.
yes, I'm correct. Your lordship was quite right in making the assessment that by 3 o'clock the list will be over. Lordship, in the election petition, lordship will kindly see.
Oh, perfect.
Election petition.
Pencil. Ismail.
As I stated, my lord, basically there are two categories of allegations. At page 16 of the petition, lordship will find in paragraph 12, there are a few subparagraphs up to Roman 5. These are basically the allegations according to the election petitioner of undue influence. Now, I have already submitted, possibly I did not repeat again.
Yes, I have.
In
I have
those
already.
cases, my basic submission was that in all these paragraphs, the allegation was that workers and supporters of the returned candidate has done something.
Yes.
Assuming for the timing, my lord, as the Supreme Court has made it very clear that at this stage, your lordship will accept the election petition to be correct. Averments made is as if these allegations are correct and proved. Then your lordship has to decide if these allegations are accepted to be correct, whether a direct verdict can be given in favor of the election petition. For that matter, your lordship has to see whether the necessary ingredients of the corrupt practice of undue influence has been made out or not. Now, here is a case where the corrupt practice of undue influence has been alleged on the ground that the workers and supporters of the returned candidate, they have done something. For the timing, my lord, I am not going into the law requiring the election petitioner to give specific averments. Specific, since it is a case of corrupt practice, allegations and averments have to be very, very specific. Now, I am not going to that. Even without going into that, my lord, there is a lack of one basic material fact, and that is the, my lord, as I have argued, I will point out from the section 100 once again. There are two types of corrupt practice in section 100. One is 101B, and the other one is
101D.
Yes, that day you have.
My lord, 101B says that if the allegations are, if the corruption is committed by the election petitioner himself, sorry, the return candidate himself, or by his election agent, because election agent is an alter ego of the election return candidate himself, as if the same person. And third category is any other person with the consent of the return candidate. So these are the three categories. Now, in this case, Lordship will find they are not saying that the return candidate has done anything. They are also not saying that the election agent of the return candidate has done anything. So they are coming to the third category.
Yes.
And that is the workers and supporters. They fall in the third category. Now, if your Lordship goes to section 101B, where the first category of corrupt practice is given, my lord, it says either the return candidate or his election agent or any other person with his consent. Lordship, kindly see. I have got a specific judgment also on that, explaining what is the two types of allegations. Lordship, kindly see 101D for a moment. B says corrupt practice has been committed by a return candidate, 1. Second, or his election agent, 2. Or by any other person with the consent of the return candidate. So if you want to say that the allegations I am making with regard to corrupt practice is within the meaning of 101B, then you have to say either it is return candidate or is election agent or any other person, but with the consent of the return candidate or the election agent. Now, your Lordship will find my argument in respect of paragraph 12, subparagraphs 1 to 5, basically where that these paragraphs lack material fact. What is the material fact? What is required to be proved in order to bring home this allegation of corrupt practice of undue influence within the meaning of 101B? You have to bring home all the points necessary, all the material facts necessary. What is the material fact necessary? That either it is return candidate or it is election agent, or if any other person, then with the consent of the return candidate or the election agent. Lordship will find in none of these paragraphs, that is my basic submission, my lord. In none of these paragraphs, the petitioner is saying that these persons had the consent of the return candidate or the election agent. This material fact is lacking in all these paragraphs. And therefore, there is absence of material facts to make out a case of allegation of corrupt practice within the meaning of 101B. I'm basically recapitulating the submissions which I made on the last occasion to make it more clear, my lord. I'm trying to make it very simple before your lordship. Now, that being the position, it relaxes the material fact and these paragraphs do not disclose any cause of action. Now, they may say that no, my allegation is not under 101B, but it is 101D2. Now, lordship, will kindly say what is the requirement under 101D2. 101D2 says, by any corrupt practice committed in the interest of return candidate, kindly.
Yes.
101D2. Here also there is one category of corrupt practice, but there is a difference. This says by any corrupt practice committed in the interest of the return candidate by an agent other than his election agent. So here the requirement is slightly relaxed. Any person, any voter, supporter, anybody, if he comes, because I'll show from the judgment, the Honorable Supreme Court has clarified that if a third person who is not known to me, he comes and does something, should I be held responsible for that? I should not be held responsible. But if the corrupt practice is of such a nature that it has materially affected the election of the return candidate, then the ground is made out. That is what I submitted. Now, lordship, kindly see, in order to prove a corrupt practice within the meaning of 101D2, merely by saying that a third person has come and done something is not enough, because 101D, lordship, kindly see the D. All these grounds coming under D, that is, one is improper acceptance of nomination paper, Number 2, corrupt practice. Number 3, improper reception or refusal of rejection of any vote. So there are 4 grounds, and lastly, Roman 4 is by any non-compliance. If there is any non-compliance of any of the provisions of the Act or the 1961 rules or any other orders passed by the Election Commission, merely by proving that there has been non-compliance, merely by proving, as in our case, by a corrupt practice is not sufficient. What is required more is that in terms of 101D, you have to show that this has materially affected the result of the returned candidate. So there is one more requirement, and Supreme Court is very clear. I've got one judgment which interprets the distinction between 101B and 101D too. In the first, I'm just repeating it, Lordship. In the first category, that is, if it is a corrupt practice within the meaning of 101B, then merely by proving that allegation is of corrupt practice is enough, provided you allege here, we are concerned with the averment. Provided your averment says that it was done by the returned candidate, this is not the case. Or it is done by the election agent of the candidate, that is also not the case. You are saying some workers, that means you are saying someone other than these 2 categories. Then you have to show that there was a consent of the returned candidate. That you have not said anywhere, nowhere they have said.
Yes.
Once they have used the word connivance, and I have got a Supreme Court judgment saying that there is a difference between consent and connivance. Connivance will not do. That judgment also I have brought. Because in one paragraph I have seen, they use the expression connivance. That is not sufficient, Supreme Court says. So, my lord, my submission is, if you say that it is 101B, then these paragraphs are lacking one thing, that is about consent. And if it is under 101D2, what is lacking is that materially affect part. Merely by saying that it has materially affected is not enough. How it is materially affected? And I have given one example, Lordship. If there is a non-compliance, or if there is supposing some act saying that there has been impersonation. So that is also an allegation of corrupt practice. By impersonation, if someone has cast a vote in favor of some persons, maybe 5 or 10, but the difference of margin between the 2 candidates, winning candidate and the losing candidate is 100. This 5 is not going to any way materially affect the result. So this is called materially affecting. So you have to show something that by which had the corrupt practice not taken place, the returned candidate would have lost the election. That is where you can show how it has materially affected. In our case, they have not been able to show anything simply by saying that materially affected is not enough. So this is with regard to the, my lord, I have just, in order to recapitulate what I submitted on the last occasion, I have made this submission.
That's to para 12.
Para 12. That I have otherwise completed on the last occasion. Today, I will be arguing on para 13. Para 13, Lordship, deals with only corrupt practice of booth capturing. Now, Lordship will kindly see from paragraph page 24, I think. Yes. Page 24, para 13. And all the allegations of booth capturing are mentioned in para 13 subparagraphs. Now, first I am coming to paragraph 13, Roman 1. That apprehending, may I?
Yes.
That apprehending booth capturing of various polling stations in 36 Nari Koyu ST Assembly constituency, the election petitioner had made a representation to the District Electoral Officer Likabali, Lower Siang District, Arunachal Pradesh, to provide adequate deployment of security in all the polling stations while representing the so and so. Page 25, manner. However, authority concerned failed to consider the same. Further, the concerned authority had even failed to install CCTV cameras in all the polling stations. As such, taking advantage of the absence of video recording, the polling agent, namely Sri Kumar Padung, along with other supporters of the returned candidate, and along with few other supporters of the returned candidate, in connivance, Lordship has seen, I submitted earlier, connivance word they have used. In connivance with the support and with the support of the returned candidate, on the date of polling, that is on 19/4/2024, captured the 21 Pote polling station at Pote village and prevented the voters in general, including the confirmed supporters of the election petitioner, for casting their votes in favor of election petitioner. One of such supporters of the election petitioner is so-and-so, and who is a voter of so-and-so, and who was to vote in 21 Pote polling station, along with his family members, were intimidated by the supporters of the returned candidate, one of whom is the Nina Kadu. Then Sri Nina Kadu, along with others in support of returned candidate, in connivance, or should you kindly note the word, in connivance with the presiding officer of the polling station, indeed cast votes impersonating the actual voters, namely Ananto Goswami, Miss Onima Goswami, then Moromi Goswami. It is also pertinent to mention here that the vote of the absentee, that is Srimati Yapa Kyadu, serial number so-and-so, was voted by the so-and-so of Pote village in favor of the returned candidate. So this is the allegation. Now, Lordship will see in this paragraph what is the allegation. First, there was apprehension of booth capturing. So these things do not make out a case of poor practice. What is actually alleged is taking advantage of the absence of video recording, the polling agent, namely Sri Kumar Padung, along with other supporters of the returned candidate. So allegation is the polling agent and along with other supporters of the returned candidate. So they fall in the category of persons, either third person within the meaning of 101B. So there you have to say that with his consent. Consent is not there. Allegation is only connivance. My submission connivance word will not do. And secondly, if they say that it falls within the meaning of 101D2, that is in the interest of the returned candidate, if anybody does anything, any agent does anything, then you have to show how it has materially affected. For the purpose of showing that it has materially affected, my lord, they have given the names of some of the persons whose votes have been cast by impersonation by committing the practice of booth capture. Lordship, 2-3 members, assuming for the timing that these allegations are correct, Supreme Court says, my lord, at the stage of consideration of an application under Order 7, Rule 11, Lordship will accept all the allegations to be correct. And after accepting, if your Lordship finds that a direct verdict can be given in favor of the petitioner, then my petition under Order 7, Rule 11 cannot be considered at this stage. But here is a case now, my lord, if all these allegations are accepted to be correct, what the material facts required for bringing home the charge of corrupt practice of booth capturing will be, my lord, Section 135A of the Act, I'll come to that Act later on. 135A of the Act clearly says what is actually the nature of booth capturing. How and in what situation it can be said that there was actual booth capturing. The entire booth has to be seized. All persons, officials will have to be chased out, saying that please go away, we are now in charge. I'll come to that, my lord, provision later on. What I'm saying at this stage is, my lord, their allegations are lacking in two respects. One, they are not saying the consent of the returned candidate is there. It is only the word is connivance. Now, Supreme Court says how, where, and when the connivance consent was taken, that you have to state here. Those particulars, those material facts are not here. This is my first submission. Secondly, my lord, they are not saying any consent. If you are not saying any consent, it will not come under 101B. And if you do not show how it is materially affected, because difference is of about 1,000, I think. So 4 or 5 persons assuming that there was impersonation, this will not materially affect the result of the returned candidate because different margin is about 1,000, 1,600. So that being the position, my lord, the allegations made in paragraph 13(1) lacks the material facts and particulars necessary to make out a case of booth capturing on the ground that the specific material facts regarding booth capturing as to how the booth was captured, in what manner, when, who has done it, those things are absent. Number one. Number two, my lord, there is no allegation that the returned candidate has given any consent. Because for giving consent also, if the allegation is that his consent was there, they have to give materials. Who took the consent, from where, how, when, all these materials are necessary. In the absence of this, my lord, the allegations will be devoid of any merit. And thirdly, my lord, if they say that it is coming under 101D2, then they have to show how it has materially affected. That also they could not show, because they are showing impersonation only in respect of 4, 5, or maybe 6 voters. But when the difference is 1600, the question of materially affecting the result of the election will not arise. So that being the position, my lord, this paragraph 13(1) is liable to be held as not disclosing any cause of action. My lord, ours is a petition where we have filed the petition under both the provisions, Order 7, Rule 11, and Order 16, Rule 6, Order 6, Rule 16. The petition we have filed is to show that since these paragraphs do not disclose any cause of action, Lordship will invoke your Lordship's power of striking out pleadings within the meaning of Order 6, Rule 16 of the Civil Procedure Code. And after these paragraphs are struck out from the petition, if your Lordship finds the petition does not have any cause of action, then in exercise of your Lordship's power under Order 7, Rule 11, Lordship will reject the petition. This is our petition here. So what I am submitting here is, in view of my submissions, my lord, my submission in respect of paragraph 13(1) of the petition, my submission is that these paragraph, the statements made in this paragraph do not disclose any cause of action of para practice of booth capturing. Then I am coming to 13(2), Lordship, paragraph 13(2). 13(2) reads like this manner, that it is also opposite to state here that after capturing 21 Pote polling station, the supporters of the returned candidate had also cast votes of absentee so-and-so Mangal Singh Yadav, serial number so-and-so, and his family, and also those of the absentees who had cast their votes through postal ballots in favor of the returned candidate, which had materially affected the result of election. Absolutely vague. Absolutely vague. They are readily saying that booth was captured, as if a court has to assume that booth was captured. And secondly, in respect of one person, there is allegation of, my lord, impersonation. My lord, had it been a case where the margin of votes by which the returned candidate had won the election been only one, then this allegation, this paragraph, I could not have prayed for striking out on the ground of absence of any cause of action. Because they say that one person's vote was cast by impersonation. If they ultimately succeed in proving this, then this will materially affect my election, provided the difference of votes is only one. Here, the difference of votes is 1600. If this allegation is ultimately proved also in the trial of the election petition, my lord, this is not going to change the nature and character of the, my lord, the result of the election of the returned candidate, because there is a question of only one vote, one person impersonation. Apart from the fact that, my lord, how it has been done, whether there was any consent, nothing is alleged. Whether it is coming under section 101B or 101D2, there is no allegation, no statement, no nothing. It is absolutely vague. Possibly, I need not make any further submission in respect of 13(2), my lord. Now, coming to 13(3). After capturing, again, they are assuming that there was a capture. After capturing 21 Pote polling station on the polling day, in connivance, Lord will kindly note the word, again the word connivance. In connivance with the presiding officer, not with the returned candidate. In connivance with the presiding officer in respect of the said polling station, the supporters of the returned candidate, including Sri so-and-so, with the active support, again, of the returned candidate, even cast the vote of deceased person, namely Tajum Kadu of Pote, who expired in so-and-so and whose name is reflected in the electoral roll number so-and-so of the state polling station in favor of the returned candidate. The stiff opposition from the polling agents of the returned election petitioner in this kind of incidents of booth capturing by the supporters of the returned candidate was of no avail since the booth capturing was done with the knowledge and connivance of the presiding officer of the police station. My lord, here my lord, the allegations will fall only on the ground that connivance word will not suffice, but connivance is in with the presiding officer. The statute says there has to be consent of the return candidate. If the presiding officer has done something, and if it is done in the interest of the return candidate, then it will come under 101, 101D2. Then you have to show how it is materially affected. You are talking about one person's vote only. Again, the same question will come. Even if you succeed in showing that there was impersonation and one person's vote goes, you have to show that it is materially affected. Because corrupt practice, my lord, Supreme Court says is a serious allegation. If the corrupt practice is within the meaning of 101B, then merely by proving corrupt practice, they will succeed. Election, my result will go. But if it is under 101D, there are 4 types of allegations: improper acceptance of nomination paper, corrupt practice, then non-compliance, and then improper reception of votes. If under 100 your allegation is under this one of these 4 allegations within the meaning of 101D4, my lord, then you have to show, because D says materially affected. So merely by proving non-compliance, merely by saying that there was improper reception, because impersonation is what? Impersonation is improper reception of invalid votes. Or there may be an allegation of improper acceptance of invalid votes. So if any of this allegation coming under 101D, the petitioner has to show not only this allegation, but also how it is materially affected. These things are absent, my lord, totally absent. Now coming to next, 4, my lord, page 28, that it is to state that various other polling stations of 14 Tabi, Ripo, 11 Loglu, and 7 Sipu were also captured by the supporters and return candidate of the return candidate. Very, very vague, my lord. As such, various representations were made to the competent authority, bringing the notice of the same and prayed for fresh poll in the polling station number so and so, representatives so and so. Further, the election agent of the election petitioner had also lodged a complaint dated so and so against the polling officers of polling station in Kaki and Pote village before the officer in charge of Naring police station, Lower Siang district, and also to substantiate the booth capturing incident of the return candidate and its supporters. The election petitioner had provided documentary evidence to the election officer. These things do not make out any case of fraud practice. I have made a representation. I have erased something in the representation. Your petition should contain material facts, madam. This is the requirement. Petition is absent, only one sentence. That it is also to state that various polling stations of, namely 14 Tabiripo, 11 Loglu, and 7 Sipu were also captured by the supporters of the return candidate. And absolutely vague and not coming within the meaning of the, my lord, corrupt practice, either 101B or 101D2. That's all. No other allegations, madam. So this is the position my lordship has seen. Both the allegations of undue influence of corrupt practice are absolutely vague and doesn't contain the material facts. I have said, madam, what are the material facts? Material facts in respect of undue influence, you have to show that there was consent, no allegation of consent. You have to show that it is materially affected. That is also not there. Similarly, booth capturing, my lord, the allegations of booth capturing, I just now read 135A. 135A lays down what are the cases of booth capturing. Merely by saying that someone has come and captured the booth and cast votes in the name of the real voters, my lord, is not sufficient in my humble submission. Lordship, may kindly have a look at this 135 for a moment, my lord. 135A.
Yes.
135A says, my lord, offense of booth capturing. Whoever commits an offense of booth capturing shall be punishable with imprisonment for a term which shall not be less than 1 year, but which may extend to 3 years and with fine. And where such offence is committed by a person in the service of the government, he shall be punishable with imprisonment for a term which shall not be less than 3 years, but which may extend to 5 years and with fine. Now, explanation, this is important. For the purposes of this subsection and section 20B, booth capturing includes, among other things, all or any of the following activities, namely, seizure of a polling station or a place fixed for the poll by any person or persons making polling authorities surrender the ballot papers or voting machines and doing of any other act which affects the orderly conduct of election. No allegation, my lord. Then B, taking possession of a polling station or a place fixed for the poll by any person or persons and allowing only his or their own supporters to exercise their vote to vote and prevent others from free exercise of their right to vote. This is also not there. Then C, coercing or intimidating or threatening directly or indirectly any elector and preventing him from going to the polling station or a place fixed for the poll to cast his vote. This allegation is also not there, my lord. D, seizure of a place for counting of votes by any person. My lord, there is no allegation that at the time of counting something has happened. This allegation is also not there. And then E, doing by any persons in the service of the government of all or any of the aforesaid activities or aiding or conniving at any such activity in the furtherance of the election of a candidate. So, Lordship, in the present election petition, there is absolutely no allegation of the nature given in this explanation to section 135A. They are simply in one sentence saying that booth was captured, votes were cast in the name of the valid voters by impersonation. That is not sufficient in my humble submission. Your allegations will have to be very specific and material facts necessary with particulars because there is an allegation of power practice. Now, Lordship, will kindly see section order 6, rule 16 for a moment. And today I'll complete that while proceeding in that way. Because our present petition is under order 6, rule 16, read with order 7, rule 11. Order 6, my lord, deals with pleading.
Yes.
And order 6, rule 16 gives power to this honorable court, my lord, to strike out pleadings. Lord, may kindly have a look at order 6, rule 16. The court may, at any stage of the proceedings, order to be struck out or amended any matter in any pleading, which may be unnecessary, scandalous, frivolous, or vexatious, or which may tend to prejudice, embarrass, or delay the fair trial of the suit, or which is otherwise an abuse of the process of the court. In our case, Lord, you will find all these allegations are absolutely vexatious. There is absolutely no material to make out a case of poor practice or undue influence within the meaning of section 123, subsection 2 and subsection 8. Because in subsection 2, undue influence is defined, and subsection 8, my lord, booth capturing is defined. So this is order 6, rule 16. And then for a moment, Lord, will kindly see order 7, rule 11. I'll cut short it as far as possible, my lord. Order 7, rule 11 says rejection of plaint. The plaint shall be rejected in the following cases where it does not disclose any cause of action. That is the ground on which I am saying that the present election petition should be rejected because CPC is applicable to the proceedings of the election petition in terms of section 87 of the Act.
Yes.
My lord. I'm just showing my lord, from section 87, procedure before the High Court of the Act, my lord, 1951, Representation of People Act. It says, subject to the provisions of this act and of any rules made thereunder, every election petition shall be tried by the High Court as nearly as possible in accordance with the procedure prescribed under the Civil Procedure Code for trial of suits. Your lordship is aware of that.
Yes.
So that being the position, my lord, my submissions, as your lordship has seen, is in respect of undue influence, and both. First is the material facts necessary to consider the offense. It's an offense for practice within the meaning of section 123. Or should kindly see for a moment section 123. This is what I wanted to point out. 123, subsection 2 defines, my lord, the undue influence.
Yes.
Subsection 2, my lord, undue influence. That is to say, any direct or indirect interference or attempt to interfere on the part of the candidate or his agent or of any other person with the free exercise of an electoral right. And 123 subsection 8 deals with booth capturing. Subsection 8 says booth capturing by a candidate or his agent or other person. Within which category it will come, my lord, will be determined in terms of the grounds of setting aside an election under section 100. So in view of this, my lord, my submission is that none of these paragraphs disclose the cause of action necessary to constitute the allegation or of corrupt practice of undue influence or booth capturing, my lord. That in that view of the matter, all the paragraphs of paragraph 13 and 12 and 13 may be struck out, and after striking out these paragraphs, my lord, naturally, my lord, the election petition will be left with no allegation, not to talk of any cause of action. There will be no cause of action because entire cause of action is, my lord, mentioned in these two paragraphs only. So your lordship will exercise your lordship's power under order 7-11 and reject the election. So I am relying on certain judgments, and I have prepared a paper book as a paper judgment. Page number to telecode. My lord, in this, my lord, compilation, there are 9 judgments lords will find. In addition to that, my lord, there are 2 judgments, citations, handwritten below that. Those, my lord, I'll supply extra copies. Your lordship need not take the pain, my lord, getting the book from the library. I am first, my lord, going to the first judgment of 99-1 SSC page 666. Well, my learned friend is there is no counsel appearing for the other side. I have an extra compilation I can hand over them.
Yes, Mr. Tadakte, one extra copy was with Mr.
Before-
Mujumdar, in fact, to supply with you. Is there anyone appearing on your behalf at principal seat at Guwahati?
Lordship, I have a friend out there. I have a colleague, so I can ask if
Okay,
that
You
that
can
is
collect
convenient.
from my learned friend, Mr. Deori, you can collect the extra copy of compilation we have made for you also.
Okay.
And from the compilation, Lordship will find the first judgment is 99-1 SSC page 666. There it starts from page 1. Lordship will straightway go to page 12.
Yes.
My lord, paragraph 11, page 12, paragraph 11. I am reading, my lord. This court has repeatedly stressed the importance of pleadings in an election petition. Para 11.
Yes.
My lord, lordship may take down, my lord. I am relying on para 11, 12, 13.
11, 12, and 13.
Put it to them. My lord, on the first page, my lord, right hand side, there is a column meant for para. I think we have mentioned paragraph.
Yes, yes, you have already.
11, 12, 13.
Yes,
my lord.
yes, yes.
So, lordship, para 11 says, the court has repeatedly stressed the importance of pleadings in an election petition and pointed out the difference between material facts and material particulars, While the failure to plead material facts is fatal to the election petition and no amendment of the pleading could be allowed to introduce such material facts after the time limit prescribed for filing the election petition, the absence of material particulars can be cured at a later stage by an appropriate amendment. In Balwant Singh versus so-and-so, the Constitutional Bench held that an election petition was not liable to be dismissed in limine merely because full particulars of court practice alleged were not set out. On the facts of the case, the court found that the alleged court practice of hiring of vehicle for the conveyance of the voters to the polling station was sufficiently set out in the pleading. The court pointed out that the court practice being hiring of or procuring of the vehicle for the conveyance of the electors, if full particulars of conveying by a vehicle of electors to or from any polling station were given, Section 83 was duly complied with, even if the particulars of the contract of hiring, as distinguished from the fact of hiring, were not given. Next is para 12. Para 12 is a judgment I am relying here. Lordship may take a note, but this judgment I have separately given, so I'll read from there. Then, my lord, para 13, Lordship will kindly say para 13 is important. On para 13, your Lordship may simply take the note, but this Udhap Singh judgment also I have separately given, my lord.
Okay.
Para 13, Udhap Singh, in Udhap Singh versus Madhav Rao Scindia, a division bench of this court explained the distinction between material facts and material particulars. All the primary facts which must be proved at the trial by a party to establish the existence of a cause of action or its defense are material facts. In the context of a charge of court practice, material facts would mean all the basic facts constituting the ingredients of the particular court practice alleged, which the petitioner is bound to substantiate before he can succeed on their charge. Whether in an election petition a particular fact is a material or not, and as such required to be pleaded, is a question which depends on the nature of charge level, the ground relied upon, and the special circumstances of the case. In short, all those facts which are essential to clothe the petition with a complete cause of action are material facts, which must be pleaded, and failure to plead even a single material fact amounts to disobedience of the mandate of Section 83(1)(a). Then 43 is also there, Madam. I'm skipping here for the timing. Para 15, Lordship will kindly see this, sorry, page 15. Para 15 is there at page 15. In Gajanan, Krishanji, Papat, etc., my lord, then para 16 of that judgment is quoted, Lordship has seen. Now, the last sentence, maybe from the bottom, fourth line from the bottom of this para 16, right hand side, Lordship will find since pleadings. Lordship has got, my lord.
Yes.
Since pleadings play an important, Lordship will kindly take the note, my lord. Since pleadings play an important role in an election petition, the legislature has provided that the allegations of corruption must be properly alleged, and both the material facts and particulars provided in the petition itself, so as to disclose a complete cause of action. Then I go to the next judgment, my lord, that is Udhap Singh's judgment, which has been mentioned here. Starts from page 21, but I'm taking your lordship to paragraph 39, which your lordship will find at page 32, my lord, running page 32.
Yes.
Now, there was an argument that as against this, Mr. So-and-so has pointed out that all the material facts as distinct from material particulars necessary to constitute a complete cause charge of court practice under Section 123(2) against the so-and-so, a candidate can be found in the petition if the same is read as a whole. That was the argument, my lord. In any case, the identity of C so-and-so as a candidate was admitted by the petitioner in the particulars supplied by him pursuant to an order of this court so-and-so. Those particulars, according to the counsel, are to be treated as part of the petition pleading. It is further submitted that if there is any deficiency of particulars, this is important. It is further submitted that if there is any deficiency of particulars as distinguished from material facts in para so-and-so, then also they could be supplied even after the expiry of the limitation for the petition. pursuant to an order of the court made at the instance of the respondent. The petitioner cannot, it is stressed, take advantage of this his own default. This is the finding of the Supreme Court, my lord. The petitioner cannot, it is stressed, take advantage of his own default in not setting forth full particulars of basic facts set out in the petition. Now, section 83 lays down that an election petition shall contain concise statement of material facts on which the petition relies, and shall set forth the full particulars of any court practice that the petitioner alleges. So the requirement are twofold, my lord. The full material facts will have to be given, and if the allegation is of oral practice, then the full particulars also should be given. Then, my lord, Lord, kindly say for para 14(1) is very important, like our case, my lord. Like the Code of Civil Procedure, this section also envisages a distinction between material facts and material particulars. Clause A of subsection 1 corresponds to Order 6, Rule 2, while Clause B is analogous to Order 6, Rule 4 and 6 of the Code. The distinction between material facts and particulars is important because different consequences may flow from a deficiency of such facts or particulars in the pleading. Failure to plead even a single material fact leads to an incomplete cause of action, and incomplete allegations of such charge are liable to be struck off under Order 6, Rule 16 of this Code of Civil Procedure. So if the cause of action is incomplete, then Lordship will exercise power under Order 6, Rule 16, will struck off that. If the petition is based solely on those allegations which suffer from lack of material facts, the petition is liable to be summarily rejected for want of cause of action. In the case of a petition suffering from deficiency of material particulars, the court has a discretion to allow the petitioner to supply the required particulars even after the expiry of the limitation. So, my lord, what this judgment says is, my lord, if the material facts are there, requirement under section 83 of the Representation of People Act is that you have to supply the material facts, whatever may be the allegation. It may not be an allegation of court practice. It may be an allegation of any other thing, non-compliance of the procedure, rule, act, etc. In those cases, you have to supply the material facts. But if there is an allegation of court practice, in addition to giving the concise statement of material facts, you have to give the full particulars. Now, for any reason, if at the time of filing of the petition, my lord, full particulars are not given, then Supreme Court says you can supply these full particulars subsequently, even after the expiry of the period of limitation of 45 days. But material facts you cannot supply subsequently after the expiry of the period of limitation. This is the tenor of the judgment of this case, my lord. Then, my lord, I'm coming to the next judgment, that is Samant N. Balakrishna. This is very important, my lord. It starts from page 36, and I am referring to para 23. Here, my lord, that distinction I was submitting, my lord, in respect of 101B and 101D2 have been very clearly stated. Page 45, you will find.
Para 23.
Para 23. Section 81 of the Representation of People Act 1951 enables a petitioner to call in question any election on one or more of the grounds specified in section 101 and 101 of the Act. Petition must be made within 45 days. Well, then few lines we can skip from top, my lord. 1, 2, 3, 4, 5, 6, 7. 8th line from top, lord, you'll find right hand side, the second subsection.
Yes.
Second subsection lays down an additional condition which must be satisfied before the election can be declared to be void, even though the court practice is committed by an agent other than the election agent. Section 101 sets forth the grounds on which a candidate other than the return candidate may be declared to have been elected. Section 101 actually does not add to the grounds in subsection 100, and it mentions in section 81 seems somewhat inappropriate. Section 100 and 101 deal with the substantive law on the subject of elections. There are two sections. These two sections circumscribe the conditions which must be established. Here, Lord, you will find what is the material fact, which must be established before an election can be declared void or any candidate declared elected. Now, this is important. 24. The heads of substantive rights in section 100 subsection 1 are laid down in the two separate parts, which I was arguing, my lord. The first dealing with the situations in which election must be declared void on proof of certain facts, and second, in which the election can only be declared void if the result of the election, insofar as it concerns the return candidate, can be held to be materially affected on proof of some other facts. Without attempting critically to sort out the two classes, we may now see what the conditions are. In the first part, they are that the candidate lacked the necessary qualification or had incurred disqualification, that a corrupt practice was committed by the returned candidate, his election agent, or any other person with the consent of the returned candidate or his election agent, or that any nomination paper was improperly rejected. This is the first. These are grounds on proof of which, by evidence, the election can be set aside without any further evidence. Merely by proving these things is sufficient. The second part is conditioned that the result of election, insofar as it concerns a returned candidate, was materially affected by the improper acceptance of nomination or by a corrupt practice committed in the interest of by an agent other than an election agent, or by the improper reception, refusal, or rejection of votes, or by non-compliance with the provisions of the Constitution or of the Representation of the People Act or rules or orders made thereunder. This condition has to be established by some evidence, direct or circumstantial. It is therefore clear that substantive rights to make an election petition are defined in these sections, and the exercise of right to petition is limited to the grounds specifically mentioned. Now, this paragraph, Lord, will kindly permit me to read this. Here they have, the Honorable Supreme Court has clarified further. Pausing here, we may view a little more closely the provisions bearing upon corrupt practices in section 100. There are many kinds of corrupt practices. They are defined in section 123, like in our case, 120 subsection 2 and subsection 8 of the Act. We shall come to them later, but the corrupt practices are viewed separately according as to who commits them. The first class consists of corrupt practice committed by the candidate or his election agent or any other person with the consent of the candidate or his election agent. This is the first category. These, if established, avoid the election without any further condition being fulfilled. If these allegations are fulfilled, nothing else is required to be further proved. Then there is the corrupt practice committed by an agent other than the election agent. Here, an additional fact has to be proved that the result of election was materially affected. This is what I was saying, my lord. We may attempt to put the same matter in an easily understandable language. The petitioner may prove a corrupt practice by the candidate himself or his election agent or someone with the consent of the candidate or his election agent, in which case he need not establish what the result of the election would have been without the corrupt practice. No further condition necessary. The expression any other person in this part will include an agent other than an election agent. This is clear from a special provision later in the election section about an agent other than an election agent. The law then is this: if the petitioner does not prove a corrupt practice by the candidate or his election agent or any other person with the consent of the returned candidate or his election agent, but relies on a corrupt practice, he must additionally prove how the corrupt practice affected the result of the poll. Unless he proves the consent to the commission of the corrupt practice on the part of the candidate or his election agent, he must face this additional burden. The definition of agent in this context is to be taken from the section 123 sub explanation, where it is provided that an agent includes an election agent. So, Lordship has seen, my lord, if he says that there was consent, then it comes within the meaning of 101(d)(2) by a third person. Then, my lord, they have to show additionally that it is materially affected. But if it comes within the meaning of 101(b), then merely by proving corrupt practice is enough. That means he himself has done, or his election agent has done, or a third person with his consent or his election agent's consent. But in our case, there is no allegation that any consent was taken from him. And admittedly, they have said about workers and supporters. So they fall in the third category. But to allege corrupt practice against third category, you must show that there was consent. Consent is lacking. So that material fact of consent being absent in the election petition, my lord, those paragraphs are suffering from lack of material fact. That is why I say, my lord, these paragraphs do not disclose any cause of action. Then next is, my lord, Azhar Hussain versus Rajiv Gandhi, reported in AIR 86 Supreme Court, page 12. And Lordship will kindly turn to page 70, page 66. Yes. It starts from page 66. I'm reading from page 74, my lord. Page 74, my lord, 9, 10 is there. And in fact, I'm relying on paragraph 8, 9, 10, 11, 12. I have mentioned in the first page itself. 8 speaks about, my lord, the section requirement under section 83, then order 6 rule 16, then 9 about section 83 and 86, 10 about, my lord, the plea, my lord. 11 is important, my lord. Just 2 paragraphs I'll read, my lord. Para 11 and 12.
That's all the agenda from the record.
I'm sorry to trouble your lordship. These judgments, these paragraphs are very relevant. That is why I'm reading, my lord. Otherwise, the subject is very boring.
11, yes.
Yes, para 11. In view of this pronouncement, there is no escape from the conclusion that an election petition can be summarily dismissed if it does not furnish cause of action in exercise of the powers under the Code of Civil Procedure. Lordship will exercise your lordship's power. So also it emerges from the aforesaid decision that appropriate orders in exercise of powers under the Code of Civil Procedure can be passed if the mandatory requirements enjoined by section 83 of the Act to incorporate the material facts in the election petition are not complied with. This court in Samant case has expressed itself in no unclear terms that the omission of a single material fact would lead to an incomplete cause of action, and that an election petition without the material facts relating to corrupt practice is not an election petition at all. So also in Udhap Singh, these I have read already, Udhap Singh and Samant, both I have read. Now paragraph 12, my lord, down below, I am not reading the entire paragraph. From the bottom, my lord, 7th line, if your lordship comes, your lordship will find the whole purpose. The whole purpose, my lord.
Yes.
Yes. My lord, this is what I was saying, that what is the purpose of laying this law that you have to plead material facts, etc. The whole purpose of conferment of such powers is to ensure that a litigation which is meaningless and bound to prove abortive, because ultimately if they fail, it will amount to, it will be abortive, should not be permitted to occupy the time of the court and exercise the mind of the respondent. The sword of Damocles need not be kept hanging over his head unnecessarily without point or purpose. Even in an ordinary civil litigation, the court readily exercises power to reject a plea if it does not disclose any cause of action, or the power to direct the concerned party to strike out unnecessary, scandalous, frivolous, or vexatious parts of the pleadings, or such pleadings which are likely to cause embarrassment, etc., etc., my lord. So, my lord, lordship has seen in this paragraph, I'm not reading the whole paragraph. Towards in the middle of this, the almost Supreme Court has further said that such being the position in regard to matter pertaining to ordinary civil litigation, there is a greater reason for taking the same view in regard to matters pertaining to elections. So long, I'm reading from the middle of this page 1776, my lord. So long as the sword of Damocles of the election petition remain hanging on elected member of the legislature would not feel sufficiently free to devote his wholehearted attention to the matters of the public importance, which clamor for his attention in his capacity as an elected representative of the concerned constituency. the time and attention demanded by his elected office will have to be diverted to the matters pertaining to the contest of the election petition. Instead of being engaged in a campaign to relieve the distress of the people in general and of the residents of his constituency who voted him into office, and instead of resolving their problems, he would be engaged in campaign to establish that he has in fact been duly elected. So this is the reason, my lord, that if it can be nipped at the bud, your lordship will exercise your lordship power and dismiss the petition in the beginning itself. So this is the section. And then, my lord, this serial number 5 starts from 97. And I'm relying on, my lord, para 55. This your lordship will find at page 113, my lord. Para 55 has basically quoted two paragraphs from this judgment of Harkirat Singh versus Amrinder Singh, which speaks about the distinction between material fact and particulars. And I'll not read this again and again. This entire judgment contains this. So lordship will kindly take note of para 55 and then 56. 56 is important, my lord, relying on a judgment of Supreme Court of 2008. Just 2 lines had been added in paragraph 20 of that judgment. The election petition is a serious matter and it cannot be treated lightly or in a fanciful manner, nor is it given to a person who uses this as a handle for vexatious purpose, as in the present case, madam. Just saying that booth was captured and then they impersonated. These are all vague allegations, madam. If there is a serious allegation of booth capturing, they will say that on such and such date is there, of course, at such and such time, the two persons have come with these weapons, because unless they intimidate, Supreme Court says in 130, the Act says in 135, the persons the officials who are in charge of the particular polling station will have to be intimidated. The police station should be seized so that the officials cannot do anything. That is called, my lord, booth capturing. Simply if I make a statement, my lord, the booth was captured and votes were cast, this is not sufficient. This is what the Supreme Court is indicating again and again, madam. So in this case, it says to handle or for vexatious purpose. It's purely for vexatious purpose in this case, my lord. Then para 57 is important. Then, my lord, 59, or should you kindly see, it says that material facts will have to be there. Particulars you can supply subsequently. And then 60 says, according to the appellant in election petition, there was no averment where the borewells were dug with the consent and or active knowledge of the appellant. So the consent part is also missing here. Then, my lord, lordship may kindly come to the, for the timing, my lord, this serial number 6 I am skipping. Then the next judgment is Dahiben with regard to Order 7, Rule 11, and it starts from page 121, my lord. And I am relying straightway on page 131, para 23.1. I have given the numbers in the on the first page, madam. So para 23.2, lordship will kindly see page 132. The remedy under Order 7 Rule 11 is an independent and special remedy where the court is empowered to summarily dismiss a suit at the threshold without proceeding to record evidence and conducting a trial on the basis of evidence adduced, if it is satisfied that the action should be terminated on any of the grounds contained in this provision. So that is the power under Order 7 Rule 11, madam. Then para 23.6, lordship will kindly see, 23.4, that Azharuddin Rajiv Gandhi judgment has been quoted here. Then 23.6, Order 7 Rule 11, under Order 7 Rule 11, a duty is cast on the court to determine whether the plaintiff discloses a cause of action by scrutinizing the averments in the plaint, read in conjunction with the documents relied upon, or whether the suit is barred by any law. So that being the position, my lord, lordship has power under Order 7 Rule 11 to scrutinize the petition and see whether any cause of action is made out or not. Then, my lord, I am relying on the last judgment, that is page 176, only one paragraph and paragraph 23. Page 185, Lord will find 185.
Yes.
Only one for one particular aspect I am referring to this
Para?
paragraph.
Para?
Para 23, my lord.
Hmm.
I have given in the first page, my lord, in the
Yes.
index I have given.
Yes, yes, I have like.
This
But
court
for
has,
my convenience, actually, I am just
Mine.
flagging it.
Absolutely.
Okay, yes.
This court has repeatedly pointed out the distinction between material facts and particulars. Insofar as material facts are concerned, this court has held that they should be fully set out in the election petition. And if any fact is not set out, the petitioner cannot be permitted to adduce the evidence relating thereto. So what I'm saying is, my lord, one argument may come forward saying that so one particular aspect we have not dealt with in the pleading, we will supply at the time of evidence. No. If the pleading is not there with regard to the requirement of material facts, subsequently by supplying evidence, you cannot fill up the lacuna because no amount of evidence can be looked into if there is no supporting pleading. Then, my lord, in this index, you will find there's one judgment of 1992, 2 SCC 612, only one paragraph and relying para 8, my lord. Para 8, my lord, I am not reading the whole paragraph. My lord, in the middle, Lordship will find there is a sentence during the post-independence. Page 618, my lord, para 8.
Yes.
In the middle, my lord, Lordship will find during the post-independence. Before that, my lord, there's what booth capturing Lordship will find. Booth capturing.
Yes, during post-independence. Yes.
During the post-independence era, 10 parliamentary elections have entrenched democratic polity in this country, which cannot be permitted to be eroded by showing laxity in the matter of booth capturing, which has now been made an offense under section 135A of the Act. The allegation of booth capturing and rigging, if proved, is a corrupt practice under section 101B and materially affects the result of the election under 1D and also is a disqualification. Therefore, the allegation must be specifically pleaded, giving material particulars. This is for this sentence only I am relying on this paragraph. It's specific, it has to be very specific and giving material particulars. Then, my lord, the last judgment I am relying is incidentally a judgment arising from the state of Arunachal Pradesh itself, my lord. 2012, 3 SSC, if my learned friend has got, I think he will have it once we supply this compilation. 2012, 3 SSC, 236, Marquio Tado versus Takam Sorang. My learned friend may be knowing also.
Yes, Lord.
About the judgment. It was passed by the some court, then matter went to Supreme Court, my lord. I am relying on paragraph 23 to 28 of the judgment, my lord. Para 23, Lordship will see, my lord. In the present case, the election petition filed by the first respondent made, Lordship has got the judgment.
Yes.
The grievance of booth capturing, which is a corrupt practice covered by under section 123(8) of the 1951 Act. Committing a corrupt practice is a ground to declare election void under section 101D of the Act. Booth capturing is also made an offense under section 135A of the Act, and the term booth capturing is also spelled out in explanation to that section. Section 135A along with the explanation reads as follows. My lord, I need not read, I have read already 135. Then, my lord, para 25. As far as impersonation or double voting is concerned, such actions would amount to improper reception of votes. This is not a corporate, this is improper reception of vote, which is a separate ground for declaring an election to be void under section 101D3 of the said Act. This ground was not pleaded in the petition, nor was any issue framed, and that's a different thing. As can be seen from explanation to section 135A, this is important, my lord. The main element of booth capturing is use of force or intimidation. In our case, nothing has been pleaded. What kind of force was used and how the persons there, officials or other voters, were intimidated. As against that, impersonation or double voting involves cheating or deception. Thus, these two grounds deal with two different aspects of the court practice. That being the position, the question is as to who, then the facts of that case that we can avoid here. So, para 27, Lordship will kindly see, it is thus obvious that having failed to place any material with respect to either booth capturing or impersonation, the first respondent was trying to make fishing and roving inquiry to improve his case by calling for the record of the voters register from Itanagar constituency in support of his grievance of double voting. In the absence of any evidence with respect to the persons who, at the instance of the appellant, allegedly captured the booths or made double voting or impersonation in so, no such inference could have been drawn against the appellant. And then last paragraph, para 28. Besides, the ground of improper reception requires a candidate to show as to how the election, insofar as it concerns the return candidate, was materially affected in view of requirement of section 101D of the Act. So, as I have submitted my note, improper reception comes within the meaning of 101D. There you have to show it has materially affected, in addition to impersonation. So, these being the position, my lord, my humble submission with your lordship is, this is a clear case where just to harass the return candidate, the election petition has been filed. The entire election petition is devoid of any material fact of undue influence or fraud practice, my lord. These allegations, all the allegations are vague, and no particulars, not to talk of no material facts, not to talk of particulars, are incorporated in the election petition, my lord. This requirement of material facts and particulars, so far as the Act is concerned, Lordship will find in section 83. I'm sorry, my lord, in the beginning itself I should have pointed out. In section 83, Lordship will find the what the election petition should contain. 83, man.
Yes.
Section 83, subsection 1 says, my lord, an election petition, then A, shall contain a concise statement of material facts on which the petitioner relies. I'm pausing for a moment here, my lord. In any election petition alleging anything, my lord, there may be a case where corrupt practice is not alleged. Even in that case, you have to give concise statement of material facts. But subsection B, Lordship will kindly see clause B, shall set forth full particulars of any corrupt practice that the petitioner alleges, including as full statement as possible of the names of the parties alleged to have committed such corrupt practice, and the date, Lordship will kindly see, and the date and place of commission of each such practice, and shall verify. So the Act itself says, my lord, for alleging corrupt practice, first you have to give a concise statement of material facts, then you have to give the full particulars of corrupt practice. But all these allegations are missing in our present case, my lord. All the allegations in one sentence, they are linking everything because they don't have any details, because there is no, my lord, substance in the allegations. They have just made out a case so as to file an election petition and make the person busy so that he cannot serve his persons whom he represents in constituency. And this is what the Supreme Court has said, my lord, in the case of Rajiv Gandhi's case, my lord, Azhar Hussain versus Rajiv Gandhi, that the sword of Damocles should not be allowed to hover over his head, because if in such case, it not only consumes the valuable time of the court, but also, my lord, disturbs him and dissuades him from serving the persons for whom he has been elected. So that being the position, my lord, in my humble service, this is a fit case where your lordship will invoke the provisions of Order 6 Rule 16, and after, my lord, striking out the allegations made in and averments made in paragraph 12 and 13, naturally the petition will be left with no cause of action. Then, in exercise of your lordship's power under Order 7 to 11, lordship will reject the election petition, my lord, so that it can be nipped in the bud itself. That's my humble submission, my lord. if my learned friend appearing for the other side gives his reply, if anything is necessary, I'll again might give my reply.
Yes, Mr. Tata, you are going to reply anything or to be reserved?
May I please, Lordship?
Yes.
Lordship, can it be considered as part of, because on the next day I'll be giving my reply on
Yes.
whatever learned senior counsel has submitted.
Yes. Yes, sir.
My lord, in an election petition, no order to make it part as necessary, but your lordship will have to hear this matter. No, it will not go to any other court. So the expression partner is not necessary.
Lordship.
It will come before this court only.
No, sir.
Lordship can say that or reply the matter is fixed on such and such.
Yes. Lordship, if as per the convenience of senior counsel.
No, now you will argue you choose a date because possibly your lordship will sit in Guwahati itself, or my learned friend will know better whether he himself, if he himself argues, and if he wants the matter to be taken there, he can do it subject to his convenience.
Lordship.
When and how do you want to give your reply? Just tell.
Lordship, since there is no instruction as such from will be, appearing on the next date. So, Lordship, can it be fixed on 2nd of June?
2nd of June.
2nd of June.
June, yes. If
you is a Monday, my lord. Monday.
Monday or Tuesday, that's part of
Third is a Tuesday. It's better to have it on third.
Third is a
Third.
Tuesday.
Third is a Tuesday.
Yes.
Let it be
Third.
on Tuesday, that is on the hearing day 3rd.
Yes.
3rd of June.
Lordship,
Convenient.
Lordship, if Lordship is there at Guwahati bench, at principal bench, so if for your Lordship,
Probability is there. Myself, I may be at principal seat only on 3rd of June, on that week only, because
Lordship,
this 2 week I'm not here from 19th.
Lordship.
So 19th, so 2 weeks I'll be at Kohima. So then obviously there may be my bench, next bench may be here at Guwahati.
Okay, Lordship, if
I'll maybe here.
if Lordship is there at principal bench, for your Lordship's convenience, whoever will appear on the next day
We
will
are
come down
fixing it
to
on 3rd.
principal
3rd of
bench.
Third.
3rd of June. Heard Mr. D. Mojumdar, Learned Senior, assisted by Mr. S.K. Deuri, Learned Counsel for the petitioner, oblique respondent, and also heard Mr. A. Tata for the respondent of the petitioner, so election petitioner. Mr. Mojumdar, appearing on behalf of the petitioner, is heard at length. Leaves the matter accordingly on 3rd of June, 3/6/2024.
For reply by the
of the further hearing of the matter. Okay, we are listing it on 3rd of June.
Good. Deeply obliged, Lord.
Okay.
No,